All rise. All persons having business before the Honorable Associate Judges, now residing over the District of Columbia Court of Appeals. Draw near and give your attention. God save the United States, and this on report. The report is now in session. Please be seated and come to order.
Good morning, everyone, and welcome to the District of Columbia Court of Appeals. I'm a little confused because we don't have anyone at council table here.
Your Honor, I believe she just went to the restroom.
Oh, okay, that's not bad timing. We will, that will give me the chance to ask you then, if it's okay, how you would like to, since you have some issues in your cross appeal. Often we will handle that just the normal way. The appellee can cover the issues from the cross appeal and then have the appellant. Is that okay with you, or do you prefer the?
Your Honor, Ms. Khan and I discussed, and we'd be happy either to.
Okay.
She can go first and use all of her time, and then I can go, or we can go 1, 2, 3, 4, and each reserve time. So
Okay.
Anyone has preferences on how?
Okay, our preference would be to do it the usual way. Good morning, Ms. Khan. We're just talking about whether to have the appellee go again after your rebuttal. And I guess our preference would be to have you to cover everything in your presentation and then have your rebuttal and see how that goes.
So that, just make sure I understand, no rebuttal time.
No, like sir rebuttal. Yeah, and we'll give you plenty of time to cover your issues. So,
Okay,
thank you. Let me call the case. Sorry, we're discombobulated this morning. There are two cases this morning, two separate special sittings. And the first case is number 20 FM 739 and several other numbers. ASLI, and you can help me if I'm mispronouncing this, CAROME versus Patrick CAROME. And whenever you're ready.
Thank you, Your Honors. Good morning, and may it please the court. I'd like to start by taking you back a few years and kind of to the start of this marriage. My client, whose name is, by the way, ASLI, CAROME, gets engaged to a law firm partner who's making more than $1 million a year. They agree she's going to stay home with their blended family of 4 children. He asks her to sign a 25-page prenup that he drafts, in which she relinquishes several rights that she would have otherwise had under DC law. But she signs it. It calls for them to share their earnings, and he says he won't marry her if she doesn't, and she wants to be married to him. She signs, trusting he'll keep his word. Shortly after that, he does open the marital account, but he proceeds to block all kinds of payments out of it for painting her home office, for her haircut, for her restaurant meals, for doctor's appointments, for her buying shoes and clothing. He demands reimbursement for groceries consumed by her daughter in the house, for a meal, $25 restaurant meal. And then he freezes the account altogether and stops making any deposits into it at all. The trial court finds this to be clear breaches of section 2.3 of the agreement, which calls for funds put into the marital account to be equally owned. And then after he closes the account and stops making deposits at all, the trial court finds that to be an egregious breach of contract to the tune of more than $3 million, even under his own experts' calculations. The trial court got all of that right. In fact, it's all undisputed. But it got wrong 3 important things. The first is how to interpret the term during the marriage. Now, to refresh your understanding, the agreement called for them to deposit their earnings during the marriage minus authorized deductions listed in the contract. And during the marriage, the trial court interpreted to mean until separation. And I think that conflicts with the plain meaning of that term. It conflicts with DC law, and it conflicts with the agreement itself. So let me just try to run through quickly each of those. The first is the plain meaning. I think if you ask anybody on the street what during the marriage means, they tell you from the time of marriage to divorce. The agreement itself says in 12.13, you've got to look to DC law to interpret undefined terms, the terms undefined. Let's look at DC law. This court has issued several decisions under a statute. The statute's not applicable, but the statute itself uses the phrase during the marriage. And it has held specifically that that includes the period post-separation, pre-divorce. And there's a DC code section that tells us when a marriage ends.
I guess one of the questions is, what do you mean by undefined term? And your opponent would say the term is essentially defined by other things in the agreement, including the recital. Is your argument that that's not really defining it, and so we do have to look to DC law?
So let me take you to three reactions to that. One is, if you look at the agreement itself, I'll get to the recital in 1 second, but if you look at, and I want to point you specifically to 3.2, section 3.2, which is at Joint Appendix 1, page 49. And it's talking about retirement account contributions. And it says that during the marriage, each party agrees to maintain the other as a survivor beneficiary on retirement accounts with respect to contributions made during the marriage and before separation. That it doesn't make any sense. If during the marriage means before separation, you wouldn't have that kind of terminology. So in the agreement itself, there's a contrast set up. We've cited the court to various other sections that use both terms distinctly during the marriage and until separation.
And I mean, I take your point about that. I think the difficulty for me, at least, is that it seems as though the agreement also has other places where the usage seems different, and the recital is one, which seems to treat separation as a form of dissolution of the marriage. So that seems to point against the view. And I understand your view about the relative significance of a recital relative to other parts of a contract. But even if you take like Article 5, which seems most directly relevant to this aspect of the dispute, which is about who gets what property when, its heading is disposition of property on separation or divorce. So it seems to contemplate by its heading even that if there's a separation, then everybody's going to kind of separate and distribute property. And then when you go to 5.1, again, its title is disposition of separate property upon separation and or divorce, confusingly. But then the actual text of it, when it talks about how to distribute property, refers only to separation. It actually never expressly says what you should do about distributing property or disposing of property upon divorce. And those provisions seem to point against the view that there's a marriage, people are still pouring assets into marital property at the time of separation, and then it's only at the moment of divorce that people start thinking, oh, now we need to divide property and stop creating marital property. So I'm interested in your reaction about, for example, Article 5 and how you think it does or doesn't fit into the interpretation of the agreement that you're advocating.
Yeah, let me respond to that. And let me also get back to the recital that mentions dissolution, which I think are the two issues the trial court relied on. So I think with 5.2, you have to read that pretty carefully.
Well, remember now, my question was less about 5.2 in its details and more about the whole structure of Article 5 and 5.1. But, yes. So I hope you'll wrap around at some point to that as well as the details of 5.2.
Right. So 1.7 is a very specific provision about the deposit of marital earnings into a marital account. 5.2 is a general provision about disposition of property. And it talks about the property owned at the time of separation. But if you read the provisions in Article 5, they're really about real property. They're about acquisition of property, management, maintenance, selling of property, appraisals. There's nothing in Article 5 that speaks to the disposition of the marital account. It's really all about very specific things that I think.
Are you saying you think 5.2 is inapplicable to the marital account?
5.2, if you read
I thought it was defined, the marital account is defined as marital property, isn't it?
Pardon me?
Isn't the marital account defined as marital property, and 5.2 is about division, division of marital property?
It is defined as the marital account is included, but the Article 5 doesn't speak to the distribution of the marital account. And when you think about it, marital account is money,
Well,
right?
if you don't think Article 5 governs the disposition of the marital account at the appropriate time, whenever you think that might be, what provision of the premarital agreement does, in your view?
I think the disposition of the marital account is just so obviously money that it's really not covered in this agreement, in Article 5. I think if you.
Or anywhere, in terms of its disposition?
That's right. I mean, I think it's like equally owned by the parties. He's obligated to make contributions to it during the marriage. And getting to the dissolution of the marriage recital, that obviously is a recital designed to set the stage, not designed to set the rights and obligations of the parties, but it's also inconsistent with the agreement itself to say that separation dissolves the marriage. So if you look at Article 12, you look at 12.2, it refers to actions taken to separate, to be separated, and to terminate the marriage, plainly contemplating that termination of a marriage happens post-separation. Similarly, if you look at 12.12, which is about how separation does not dissolve the marriage of the partners, separation can be undone essentially by reconciliation. So that too counteracts the notion that the marriage dissolves upon separation.
Can I get back to the theory, which I hadn't understood you to be advocating until now, so that may be a light bulb going off late for me, but that Article 5 doesn't govern the disposition of the marital account. Does it follow from that, in your view, that the trial court in entering a divorce decree here could have equitably distributed that in whichever way the trial court thought best? So that rather than thinking that the distribution that was governed by the agreement, the trial court could have said, well, I'm going to, do the kinds of things that trial judges do in the absence of a premarital agreement, and just figure out, how best to divide it.
That's right. There are obligations in this agreement that last plainly until divorce. And so I think that you've got to read the entirety of this agreement. You can't have a general provision like 5.2 undo a specific provision like 1.7.
And can you explain to me why you think 5.2 is more specific than 1.7? 1.7,
the opposite.
Yeah,
yes,
vice versa. Sorry, I misspoke. I guess your idea is that it's focused on one form of marital property, the marital account, the relevant provisions of 1.7 that you're relying on. And that 5.2 is more generally about the disposition of, I had taken it to mean all marital property. I gather your position is maybe not all marital property.
That's correct, Your Honor. I think that
1.6, just back on the theory that Article 5 doesn't even apply here. How do you square that with 5.2B, 5.2A, which refers to folks being charged with 1/2 of the marital debt, which seems, to the extent part of your theory seemed to be really 5.2 is about real property. It seems contrary to that line of thinking.
Well, let's just read it, right? Net value of all marital property. Would you refer to a bank account as having a net value? Would you look at the end of that sentence?
I might not if I was referring only to a bank account. If I was referring to various forms of property, some of which might have a value, I might use that general term. So.
Yeah, but if you read every provision, Your Honor, it talks about acquisition, care, and maintenance of property. It talks about division of property may be partly in cash and partly in kind. Obtain an appraisal. The only specific reference to something that doesn't square on to real property is E, which is at JA1 at 51, which talks about retirement benefits specifically. There's really no provision that one can say specifically speaks to the marital account. And 1.7 we know specifically speaks to a marital account. So if there is a tension here, getting back to what during the marriage has to mean, the tension would have to be resolved against Mr. CAROME. He was the drafter of this, the sole drafter, refused to take any of Ms. CAROME's suggestions. And the trial court found he was the sole drafter. Ambiguities need to be drawn against him. And so at most, you've got a during the marriage marital account contribution requirement. Again, during the marriage, I think has, under all of the metrics I mentioned earlier, only one meaning.
Can I ask you back to 5.2 and how it fits? Imagine that the parties had separated, and before divorce, one of the two parties said, okay, time to dispose of marital property. I would like, that there's a house, there's real property, which I gather you would agree is subject, assuming is potentially subject as a form of property that you think is clearly governed. Do you think that the party that's premature and couldn't be done because the marriage isn't over, or you think that property could have been distributed?
I think that property could be distributed.
So that wouldn't be premature. And
no.
So the idea would be you distribute certain kinds of property during a period when the premarital agreement is requiring one of the parties to continue, both parties really, to continue to make contributions to a separate sort of property.
Yes, and the agreement has other provisions that clearly require contributions until divorce. So this agreement does not contemplate that at separation, poof, marriage dissolves. It contemplates a divorce proceeding. And that's why I reference Article 12, which talks about the actual termination of the marriage. And so there's no reason to think that 1.7 would somehow fall away because there's a separation between the parties. I'm very short on time.
We'll give you some time to cover the issues you think are important within reason. Yeah.
Right. So I think I covered the during the marriage issue. I wanted to move to defined benefit contributions, which if you'll recall, Mr. CAROME had two retirement accounts, a 401k and a defined benefit contribution plan. The agreement specifies a formula in 1.7a, and it says that deductions to retirement plans generally can't exceed 50% of marital account contributions. The trial court found there were no contributions during the 4-year damage period, leaving aside the during the marriage issue, which would just extend the damage period, that this meant the deduction for retirement account contributions was 0, but only applied it to 401k, exempted the I'm going to call it DBP for short, defined benefit plan. Now, Mr. CAROME says that's correct because 1.7d, which is the limiter, references what a party may contribute, and the firm makes the defined benefit plan contributions. But the agreement itself says that Mr. CAROME makes defined benefit plan contributions at 1.6, section 1.6, which is at JA 142. And when he wanted to distinguish between the two plans, he did. So we've cited the court. I don't want to take the time to point you precise sections, but he distinguished. So if you look at various sections that we cited, when he means just the 401k, he specifies. When he means just the DBP, he specifies. But both 1.7a3, which is the authorized deduction for retirement plans, and 1.7d, which is the limiter on that deduction, reference retirement accounts generally. And again, to the extent there's any ambiguity about that, which I don't think there is, it would have to be construed against him. That limiting principle that the trial court applied, in my opinion, has to be reversed. The last issue is the Rollinger report. This is the report of Mr. CAROME, the expert witness. The entirety of it is reproduced in JA2. And your honors know that you've got to specify your opinion, the bases, reasons, and methodology for the opinion and the underlying facts and data. Mr. CAROME says the bases, reasoning, and methodology are found in his tables, his summary tables, which are at JA 296 to 182. Those do nothing but list categories and numbers. They tell you absolutely nothing about what the categories mean, 2 of which were brand new. They're not taken from the agreement. One of the categories, authorized deductions, was taken from the agreement, but two others were not. I think they were called contributions to the marriage and other necessary expenses, and he breaks those down, but he doesn't tell you at all how he defines those terms, what methods he used to place items into those categories. He testifies to all of that at trial, including methodology testimony around doing Google searches to find out the location of restaurants, to find out the location of gas stations. And Ms. CAROME didn't know any of that until the trial. Underlying facts and data.
Can I ask you a question about that? When you say Mrs. CAROME did not know any of that, the trial judge's reaction was that her expert understood full well what was in that the Rollinger report. And does Ms. CAROME's expert's familiarity and understanding with what is being produced here, does that get credited against Ms. CAROME for purposes of Rule 26?
So I'm glad you asked that question, Your Honor. Ms. CAROME was familiar with the authorized deductions. Ms. CAROME was not familiar, nor was her expert, with extra agreement deductions, which was over $4 million. It was the majority of what Rollinger deducted from Mr. CAROME's earnings in arriving at Mr. Rollinger's bottom line were these two categories of expenses that were invented out of whole cloth. They were not in the PA.
Well, the categories may have been, as you say, invented out of whole cloth, but there's page after page breakdown of what was in those categories. And if I understood correctly, for the most part, that the items listed were based on receipts and records that had been produced in discovery. Now, I understand that some of it was based on what Mr. CAROME may have said to
No
his
receipts were
expert,
produced.
but
It was just the Quicken spreadsheets of Mr. CAROME on which they were based. But we didn't know that until trial, meaning now we're moving to the underlying facts and data.
so it wasn't obvious to you?
No, if Your Honor could look at that report, I can't tell you how many hours I have spent with that report. I cannot, to this day, make heads or tails of half of it. I can't tell you what columns mean. I can't tell you what sources were. He doesn't specify that he talked to Mr. CAROME for dozens of hours.
But this raises the question, and I understand you say this is not a matter of error, but it's a matter of harm, but the failure to depose. Can you talk about that a little bit? I think Mr. CAROME argues that you even conceded at some point that the decision not to depose was a strategic decision to minimize risk. Does that matter? Is that true? And why wouldn't have deposing this expert just, answered your questions?
Well, it might have. There was still a lot of confusion even during the trial. After 5 days, half the trial was spent on this expert explaining everything that was missing from his report. My client made a choice because the report was modified 3 times. She thought things were going to be fixed. We alerted the other side to the problems. We asked the court to order them to fix the problems, to fill in the details. She leveraged the entirety of her retirement accounts to finance this trial and made a choice that not to take the deposition of Mr. Rollinger, thinking the report was so deficient. And that was a strategic choice. And it really left her with one hand tied behind her back. The obligation is not on the recipient to address basic requirements. So let's look at the underlying facts and data. Nowhere in that report does it say that Mr. Rollinger spoke with Mr. CAROME, looked at his Quicken registers, didn't look at any receipts because they weren't available, looked at bank statements, looked at tax returns. Nowhere. There was no knowledge of what this was based on. It was so deficient that a strategic decision was made not to bear the burden of multi-day deposition to try to tease out what could have been made eminently clear.
Can I ask you, you said a little and you say some in your brief about even a strand of the trial court's thinking is, even if there wasn't enough information, everything got excavated during trial. And so there really wasn't any prejudice because it got fixed during the trial. You found everything you needed to know during trial. You were able to effectively cross-examine. Can you just take a stab at concretely saying, no, that's not a correct way of looking at it. If you had the information that you think you were entitled to before trial, things would have been different than how they spun out of trial in which ways? I think that'd be helpful if you could be very as concrete as you can be about how you think, what you think the practical prejudice was in being worse off than your client ended up after trial.
Yeah, so there were countless instances of Mr. Rollinger assuming that Ms. CAROME was on vacations that were covered, that Ms. CAROME was at meals that were covered, that she benefited from CVS purchases. There were no receipts at all to substantiate any of this. It is certain, and honestly, they walked into that trial not knowing that almost all of this was based on what Mr. CAROME had told Mr. Rollinger.
Right, but
And
I think
so
the trial court's thinking is you made that very clear during trial, and the trial court took that into account, maybe appropriately, maybe not, but in any event, that information was communicated to the trial court. How would it have been better if that had been apparent from the report and then also would have been made apparent during trial in the same way? So how would it have been, what would have been different in terms of what would have happened at trial if you'd had that information in advance of trial?
She could have made a motion to disqualify Rollinger altogether because of his reliance on data on which experts don't typically rely. She could have produced receipts. She could have attempted to pull together all of her calendars to figure out what trips she was in fact on.
This trial went for something like 10 months. There's a lot of time in there in which she could play catch up, as it were, to produce the kind of information that you're talking about, right?
Well, it didn't. The cross-examination of Mr. Rollinger began immediately after his direct finished. I can't go back right now and reconstruct exactly, which days his test. I could, but it won't be worth the time right here. But the cross begins, and whether she would have been able to go find things and introduce them despite having not produced them in discovery, I imagine would have led to quite a big fight. We did ask at the beginning, once we lost the motion to not allow this testimony, to ask for an opportunity to depose him. And that was not granted.
See, one thing that I suppose I'm struggling with, and it's hard to put this into words with precision, is the notion that not every deficiency in an expert's report is going to be a failure to comply with Rule 26. It may be unfair to say this, but I have the impression that if Mr. Rollinger had written the report in the way that you're asking, or arguing he should have written it, instead of being a 400-page report, it would be a 4,000-page report. Is that unfair? Is that?
I don't think it would have been a 4,000-page report, Your Honor, telling us what he relied on.
Well,
Conversation.
I mean, if all you're talking about is a sentence that says, he didn't put in a sentence that said he's relied on what his client told him. Or he didn't put in a second sentence, which is he relied on all those receipts and stuff that were produced in discovery. If it's simply a question of those two sentences were missing from the report, and I'm not saying you're taking this position, but if that's all, I'm sort of skeptical that that really means the whole report really is deficient from the point of view of Rule 26. It's sort of clear enough, and the judge seemed to think it was clear enough what Mr. Rollinger's opinions were, what his analysis was on which he relied to get those opinions. And, you know, in general terms, what he was relying on. So I'm really trying to get a handle on how, you know, specific a deficiency we really have here.
Well, the facts and data on which an expert relies is not something you can just dispense with and say it's a non-issue, right? I mean, this court has said there are 3 requirements, they're independent requirements. We can't just ignore one of them because the trial court did and because Mr. Rollinger did. It's not just a sentence. It's a list at trial, and we've cited that for you in our brief. It's a list of items he looked at, and it's the omission of receipts. That was not disclosed, right? So it was quicken registers prepared by Mr. CAROME. There were no receipts. So that's an important feature of his report that Ms. CAROME would have benefited from knowing in advance to prepare.
From the perspective, again, not to push it too far, but from the perspective of a trial lawyer, you don't think Ms. CAROME was better off being able at trial to cross-examine the expert by showing that he can't basically justify all these numbers that he's got in his report? What is the basis for them? It's not in there. And that's just not,
No,
that's just not, that isn't in effect to her advantage, the deficiencies in the report.
no, because I can't tell you how much my client post-trial has gone back over this and found countless things at which she wasn't present. Countless things. But you can't do that on the fly. You've got to do that in the hard work that you sit at in your trial office, in your office, and do. And so she.
Well, of course, you had the report for a couple of months in advance of trial to be able to do that, to say, here's our strategy for attacking this.
Right, but we didn't know his methods, Your Honor. We didn't know that he conducted Google searches to assign gas station charges when in DC to her.
Okay.
Despite it turning out, we were able to find one time when the gas went into his car, one time when the gas went into the child's car, his child's car, attributed to her. So what I'm saying to you is that she was put on the fly to figure out the deficiencies. Admittedly, having not taken a deposition and trial court not pausing the trial to allow her to take one in light of its ruling, she was put to picking in ways that were severely handicapped in terms of what she might have been able to do. And I wanted to go back to your point about familiarity. This is really important. She was not familiar with $4 million of deductions that Mr. Rollinger took. Not familiar. He said she benefited from what he called contributions to the marriage. She didn't know what was in here. She didn't know what these items were. He invented them. He invented the category. He invented the subcategories. There were a dozen.
Can I ask you, I wanted just one very specific factual question and one more general question. So the specific factual question is, I think you said twice that there came a time when the trial court ruled that the Rollinger report was going to be admissible, that there was a request to depose him. I remember in the pretrial statement, there was like an alternative request, exclude it or fix it. So I remember that. Can you remind me when it was that there was the request to, because it wasn't, that wasn't in the pretrial statement that as I recall. So that was during, you know, during trial or during the lead up to trial when the ruling was made. I'm just trying to remember.
And I'm not going to be able to point you to the precise transcripts. I didn't print all the transcripts. I'm happy to send.
I'll try to, I just want to make sure that that's not in the joint pretrial statement. That is later when the trial court is orally ruling on, yes, this is going to come in. Is that roughly contemporaneously with when the trial court said, I'm going to limit you to what's in the report? Or
yes.
I think I know what that is.
I want to remind you of the timing here. Ms. CAROME asked Judge Nutter to make the ruling before trial about Mr. Rollinger. And Judge Nutter, there's an argument in the, I think it was in the pretrial, and Judge Nutter says, I'm not going to rule now. I'm going to reserve it to the first day of trial. And he does. And so there's this time lag during which that too could have been corrected. either by requiring him to address the deficiencies or allowing her, I guess, to take some further discovery. Now, the rules don't contemplate that the burden is on Ms. Carome to take extra depositions, right? I mean, the rule is, tell us at least these three things.
You're quite right. Some courts, some of which your opponent relies upon, do take the failure to take that route as relevant to harm as kind of, well, if the litigant had really cared, the litigant might have sought deposition. So it's definitely not a requirement. It may be potentially relevant to harm. The other more general question I wanted to ask is, at times at argument today, you have sort of implied that there's a substantive problem with the trial court's treatment of Mr. Rollinger's report, in that this whole category of like contributions to the marriage, extra, what you're calling extramarital agreement deductions, really should never have been, that shouldn't be a thing. You shouldn't be doing any deductions for any of that. But it wasn't clear to me that you're trying to attack the trial court's ruling on that substantive ground. I think Mr. Carome in his brief says you're not trying to make that argument. And I just want to clarify, I know you're defending the trial court's damage assessment against the cross appeal and the effort to reduce the amount of damages, but do you understand yourself to be trying to argue actually, millions of dollars that the trial court was treating as deductions never should have been treated as deductions, because this whole idea of kind of marital, extramarital agreement contributions to the marriage was not a correct way to apply the marital agreement.
Well, we're not, I think Mr. Carome is right in saying that we took that position down below, that those just are extra agreement and shouldn't qualify. I think in some sense, if Rollinger's report is eliminated, that gets you to the same place, because what's left is Mr. Eggert's report, which is my client's report, expert's report, which does not take extra PA deductions.
If the court were to conclude that the permitting Mr. Rollinger to testify, notwithstanding the alleged deficiencies in his report, was error and harmful error, I have been assuming, but tell me if you think that this is not a good assumption. I've been assuming that the remedy would be to send it back down for further proceedings. And who knows what the new record would be about all of that. I'm not sure it's obvious. It would be that all that would be left would be your expert's report and nothing else. So, I assume you'd spin out a new proceeding, and who knows how that would look.
It's hard to say precisely. Obviously, to some extent, it will depend on what you say. Makes sense, but I think that report was deficient. Mr. Carome was told it was deficient. Mr. Carome dug in his heels and persisted with it, chose not to correct the problems to which he was alerted. And that should not be a choice that should essentially allow a do-over. So the other point I just wanted to say before I'm done here is harmlessness. So, the rule is substantially justified or harmless. And Mr. Carome did not argue that the errors were substantially justified. He thought there weren't any errors at all. He did argue harmlessness. And I think that argument, it carries absolutely no water at all. I mean, this was so deeply harmful to Ms. Carome. It was the main exhibit on damages. It resulted in a reduction of her damages award by millions of dollars. So the argument that it was harmless is just really carries no weight.
Before you sit down, I don't mean to prolong your agony here, but I'd like to go back to the defined benefit plan for a moment, because I'm not sure I understand an aspect of your argument on that. The section 1.6 of the premarital agreement provides that the defined benefit retirement plan is separate property and shall not be included in marital property. And the way it reads is, it says that on the key language that I want to ask you about, it says that the plan shall remain as separate property, notwithstanding that he may make contributions to such plans or accounts during the marriage from his earnings.
Your Honor, do you?
What is the
mind telling me
significance?
Where you are? Is it that little, I just want to follow along. Do you mind telling me the little?
Oh, it's number 3, Roman 1.6
Roman 3.
3.
Okay, I'm on the wrong page. Romans 3. Wait, why can I not?
So separate property includes, that's the intro.
Oh, Roman 3, now I'm with you on JA 41, JA1 at 41.
Yes.
Yes, got it. Yes,
What do you take to be the significance of that? I'm thinking that if the defined benefit plan is defined as his separate property, not marital property, and regardless of the source of the contributions essentially to that plan, then that should be excluded from the property that is distributed as marital property. What am I missing here? I'm not sure I understand your argument.
so section 1.7 is a formula, right? It says you deposit your earnings minus these deductions. And if you read 1.7D, it says the contributions to the DBP can't be taken out of earnings. There's nothing to say that his separate property wouldn't be the source to which that deduction is attributed, if that makes sense. So the money still goes into DBP, right? He doesn't even have a choice about whether it goes in. The question is whether in the formula he can deduct it. So
And
this,
is it right that ordinarily he could have? And the reason you think he can't, it would ordinarily be a subtraction, if I understand it. And your argument is, had he complied, he would have been able to do it. But there's a
exactly.
cap. And since he didn't comply, the cap zeroed him out,
That's
even though
right.
it's something that would have been his, those contributions actually still are his property. They're just not a deduction.
Absolutely, they are his property. And even Mr. CAROME isn't relying on 1.6. He's arguing on 1.7D. He's relying on 1.7D, which is the cap. Because I think that the fact that it's his doesn't speak to.
Okay, I think I see.
Yes, okay. Thank you.
Okay, thank you very much, Ms. Khan. We will give you some time for rebuttal.
Thank you.
Good morning. May it please the court. So I'd like to start with during the marriage, and then I'll discuss the defined benefit plan and then the damages issues.
I hate to interrupt you from the start, but could you state your name, please?
I'm sorry. My name is Mr. Lahotsky. So the question is before the court with respect to Ms. CAROME's during the marriage argument is when did the specific obligation in section 1.7A of the parties' agreement end? And section 5.2A is clear that obligation ends as of the time of separation. Section 5.2 says that, quote, in the event of the parties' separation, the parties' marital property, end quote, shall be disposed of in precisely this way. Quote, each party shall receive 1/2 of the net value of all marital property owned by the parties as of the date of separation. It's true, there's no definition of during the marriage in the agreement, but there is a definition of separation in section 12.2, which says the parties shall be considered separated as relevant here, the date that one party informs the other in writing that he or she intends to be separated and to terminate the marital relationship. The parties have stipulated that happened on November 4th, 2017. And that is the date.
Can I ask you that? So that reading, which in isolation, I think makes perfect sense, seems to contemplate a world in which after the moment of separation, not only through the marital account, but through no other way will there be any marital property that like accrues. And do you think that's a correct description of the world, so that nowhere else in the agreement, same about marital debts too. So you think that, like, what happens in your view to any marital property other than the marital account? If some new marital property comes into being during separation, or if there are marital debts that are accrued during separation, what do you think the agreement says about them? Because it doesn't seem to contemplate that they would even exist, or say how to allocate.
I think as of that date, there would not be any further marital property into a joint marital account.
I understand about joint marital account. I'm asking about other ways in which marital property might come into being.
I think there are. I don't think there would be any new marital property that would come into account after the date of separation. They would have separate property.
I thought there were some obligations about life insurance payments and various other kinds of things. What about marital debt?
Could there
be any marital debt?
There would still be marital debt. There would still be certain obligations that are specified, such as in section 6.2.
And how does marital debt get distributed if it arises after separation and before divorce?
Well, I guess, as you noted, Judge McLeese, there is no provision in Article 5 for division of marital assets upon or debts upon divorce. It's only as to separation.
So I imagine that issue arose. I mean, what's the right way of interpreting the agreement then? If it's not express about it, what do you think happens? It's got to be allocated somehow, right?
I think it is expressed that the division of all marital property, marital debt happens upon the date of separation. That is when there is no longer any marital property or marital debt that's being created.
Imagine that there is a marital debt that arises post-separation, pre-divorce. Under the agreement, what's the right way of interpreting the agreement about how that gets distributed?
So in the absence of anything in the agreement that would cover it, then I do believe that the DC defaults would apply. If it's not covered by the agreement, if it's truly not covered, for instance, there's no provision in the agreement about whether the parties may remarry, but that's because DC law says you can't remarry unless you've been finally divorced. So there are certainly some things, some obligations of marriage that continue post-separation, and we're not arguing otherwise. We're just speaking about this specific obligation of the joint marital account in section 1.7a.
Can I ask you, this will reflect some fundamental ignorance about family law, so I apologize for it. Is it possible to be divorced without having been separated?
In DC, I don't believe so. I believe separation precedes divorce in most circumstances.
I thought that might be true, but I wasn't sure, because the agreement seems to contemplate that. It seems to assume that you couldn't, because it doesn't tell you what to do literally by its operative terms if there is divorce, but there hadn't already been separation. Again, headings are things like disposition on separation and or divorce, but then the actual operative text of it is only about separation.
I wondered about that same question in connection with the proper interpretation of the recital H. Because this agreement applies not just if you're divorced under the law of the District of Columbia, but by its terms, if you're divorced anywhere. And not every jurisdiction would have the same divorce laws and the same restrictions on divorce as the District of Columbia. I would imagine there are some jurisdictions where a separation is not automatically required for a divorce. Does that make a difference in how we interpret the recital?
I don't believe so for this agreement, because section 12.13 says that it's interpreted according to the laws
of the District of Columbia.
But in hypothetical terms, yes, in a different jurisdiction, it might not be the case that
because you could interpret that language in the recital a little bit differently. You could say, let me see if I have this. Nobody's made this argument, so I probably shouldn't bring it up, right? Says this agreement shall govern their rights and obligations upon dissolution of their marriage by death, separation, or divorce, regardless of where they may be living at the time. One could interpret that to recognize that separation may or may not by itself result in a dissolution of the marriage, depending on the particular jurisdiction. And so what this says is that in jurisdictions where separation by itself will result in a dissolution, of the marriage, then this agreement covers that. But it doesn't apply to jurisdictions such as the district, where separation by itself does not result by itself in the dissolution of the marriage. I came to the conclusion that's probably not the right way to read this. And nobody's made that argument, but it did strike me as an alternative way of understanding recital H.
Well, I think that's right, that it's probably not the way to read this particular agreement, given it's governed by DC law. And I think recital H supports our point about section 5.2A, which is the specific provision that dictates the result here with respect to this argument about 1.7A. But I think the overall agreement, it does speak to a lot of different ways in which the marriage could end for some purposes or for all purposes. So for instance, covers death, what happens if somebody dies, and what's the allocation of life insurance and other retirement benefits. What happens upon separation for specific property? There are provisions in 5.2 which govern.
Getting back to those provisions in 5.2 and separation, is it really, suppose there's marital property that is rented out.
I'm sorry,
Suppose there is marital property that is rented out,
okay.
and the rents are income to the marriage. I don't know if there was any property like that in this, but I'm trying to come up with a hypothetical to address the point that Judge McLeese was pursuing. Suppose some of those rents come in, are paid after the date of separation. How does, under the agreement, how would, I would have assumed that those rents are marital property and would be subject to the agreement, subject to 1.7, for example. Even though that's marital property originating, as it were, after the date of separation.
So I think two answers to that. One, if you have a rental contract that says, the renter am paying the CAROMEs this amount per month, and if I break the lease, then there's this much in damages. I do think that contract, even though it would extend beyond November 4, 2017, would be fairly considered marital property. Now, if you have, some new renter who comes in later, new contract in 2019, 2020, for instance, I think I'm less certain about whether the cutoff in section 5.2A would apply to those sort of very inchoate future streams of income. There's also a specific provision. This is my second answer, section 2.4.
Before you finish, go to the second, I'm not sure I fully get your first. So I took you to agree that in some circumstances there could be marital income that would be received. I don't know, generated is an ambiguous term, but received, let's say paid and received post separation, pre-divorce. And what I didn't get is an answer to what you think that means. What provision of the agreement would tell you how to distribute that income?
I believe it would be section 5.2A that would have to say how.
And why would that be?
Well, to the extent there is a provision that in the agreement that dictates how to deal with that rental income as marital property, I think it would have to be 5.2A because it says all marital property.
But it's I thought it said owned as of the time of separation.
Owned as of the time of separation.
So this property doesn't seem like it would be owned as of the time of separation.
Well,
to agree with your opponent's argument that on another issue to a kind of a more abstract sense of ownership about kind of expectations of income not yet received.
Well, as I said, I think if you have a contract that says, we are getting this amount of money, sort of guaranteed, that's the only circumstance in which I think you would say you've got a definite fixed property right that is marital property as of the date of separation. If there's some future contract on the rental property, I guess I don't see how that would be marital property after November 4, 2017.
Let's say they with marital funds had bought, this is a more absurd hypothetical, but they bought with marital funds, they had purchased a lottery ticket. And then after separation, before divorce, they win the lottery. I don't think anybody would think they own anything at the time of separation.
Well, no, I guess they do have an option. That is, if we win the lottery, then we get this amount. So I do think that would be the kind of contract that is a guaranteed payout as of the time the lottery ticket is bought.
It's
So
pretty condition. I mean, I guaranteed.
Well,
is an odd sense of that. It's an
I
odd use of the word
guarantee that if you
guaranteed.
win,
What, can I ask you, my sense is that this agreement is extremely imprecise and internally inconsistent about use of term separation in marriage and whether in various settings marriage exists after separation or doesn't, or they're distinct. And another provision that I wondered about a little bit is 7.1 in the premarital agreement, which says that during the marriage, that each party is responsible for debts in his or her own name. So do you think that means that upon the point of separation, that limitation in the premarital agreement is no longer in effect, and whatever happens, there may be questions about how to deal with it, but they won't be governed by the premarital agreement?
well, I think marital debts would be governed by the same provision in 5.2.
I'm just asking, do you think 7.1, let me put the question more specifically. Do you think in the phrase during the marriage in 7.1 means during that provision about how to handle debt in one of the parties' own names is applicable only up to the point of separation and ends at the moment of separation?
I think it could continue until divorce. I don't know that that provision, section 7.1, would be governed by 5.2A. Our argument is really about section 5.2A and when it ends the obligation to continue to.
I thought part of your argument was that the recital should be understood generally to indicate that the marriage under this agreement, the marriage ends on separation, because that's a form of dissolution of the marriage. So it sounds like you think that whatever inferences might be drawn in part by the recital, you don't think they necessarily would dictate the correct interpretation of phrases like during marriage and other provisions, such as, for example, 7.1.
I think if all you had was recital H, we would have a much harder argument. I think that the agreement as a whole supports our interpretation, including recital H. The marriage can certainly, or certain obligations in this agreement can end for those purposes at the point of separation. But certainly the marriage continues as a legal matter until there's a divorce.
I get all that for sure. In the agreement, some things clearly end at the time of separation. Some things clearly continue after separation. That's definitely true. And sometimes it seems to me the word separation is used in a way that seems, or other similar terms are used in a way that seems to assume that the marriage is over at the time of separation for various purposes. Other times it seems like the opposite. But is it your view that the phrase during marriage in this premarital agreement always means only up to the point of separation? That phrase, those two words, do they always mean only up to the point of separation, or is that context dependent?
I believe it is context dependent upon the entirety of the provisions that you're interpreting. That's our overall argument, that you interpret the contract as a whole, taking all of these provisions into account. That's what the trial court did. If there are no further questions.
If we conclude, I'm not saying we would, but if we conclude that during the marriage is ambiguous, where does that leave you, given that Mr. CAROME was the sole drafter of the agreement?
Well, I don't think either party argued that the agreement is ambiguous in front of the trial court.
I take that point, that each party was arguing that it's a clear meaning. You can see we all find that a very funny thing to say, right?
I think in that circumstance, we have not appealed the conclusion that Mr. CAROME was the sole drafter. I think the only extrinsic evidence that was offered to try to interpret the agreement was Ms. CAROME's testimony about what she understood it to mean. The judge found that wasn't credible, found that both parties would be willing to say anything where they thought it was to the financial advantage or disadvantage of the other. And so I'm not sure what this court would do with that. Maybe a remand would be appropriate in that circumstance rather than trying to divine it in the first instance where nobody has been arguing or developed below any extrinsic evidence.
Well, Judge Wickman asked you about one kind of canon of contract interpretation, construed against the drafter. You shifted over not unreasonably to an additional topic of extrinsic evidence. Let's assume for a moment that we are not interested in extrinsic evidence and further exploring that. And the issue is just both parties in the trial court and in this court have argued, here's a contract. We're not focusing, let's say, on extrinsic evidence. Each side thinks it unambiguously favors it. Let's say that this court concludes, no, we don't agree with that. We think it's ambiguous. In trying to and assume for a moment that if there is a contract that by its terms is ambiguous, meaning that you could possibly reasonably interpret it either way, and there's no extrinsic evidence that's going to be considered, assume for a moment that's a question of law that the trial court would determine itself as a legal question and assume that our review would be de novo. Would you agree that as we're considering how best to interpret a contract that is ambiguous, so not obviously meaning one thing or the other, that one of the things that we should be considering if we end up doing that as a matter of law, that one thing that would weigh against your client is that principle of construing ambiguities unfavorably to the drafter?
Accepting the premise of ambiguity, yes, I would agree with that. We disagree, it's ambiguous, but yes. If there are no further questions on during the marriage argument, I'll move to the defined benefit plan issue. So I think I want to take issue with one thing that Ms. Khan said, which is that we are relying on section 1.63 because it does expressly say that the entirety of Pat's Wilmer-Hale defined benefit plan is his separate property. And it says, quote, notwithstanding that he may make contributions to such plans or accounts during the marriage from his earnings. That's section 1.63. It's also JA 1 at 189, where the trial court accepts that argument.
Well, but why does that? I mean, if those were marital property, then they might not have been subject even potentially to an exclusion, but there are contributions to separate property. And so the agreement seems to contemplate, sure, they're his property and his contributions to them would be a deduction. So that's a given, all of that. And the argument that your opponent makes is, yes, but there's a cap provision, which says, although go ahead, take some of your earnings and contribute them to what would be your own property. But there's a provision that says there's a limit on how much you can do of that, because obviously if you could take all of your earnings, put all of them to your own property, your own separate property, then there'd be no joint pot for people to work from. And one of the limits is for purposes of arguably contributions like this, that's where to me, the more interesting questions lie, is you're capped to a percentage of your contribution to the marital agreement, which also makes sense. And their argument is your client made zero. So if he's capped at zero, even though all that would have been his and could have been a deduction, if he made no contributions, he gets no ability to claim any of that. And so I don't see why any of that helps you. I think if you have an argument, it seems to me it's more about what is a contribution and is there an implicit requirement to be voluntary and who has to make the contribution. But am I missing something?
Well, so I think that 1.63 is a specific provision with regard to the defined benefit plan, but let's say you disagree with us.
No, I agree.
Sure.
It is. I completely agree. It's a specific provision with respect to the defined benefit plan. I just don't see how it's a specific provision that helps your argument, because taking what you say about it is true, which is, yes, those contributions, the ultimate asset created by those contributions would be your client's sole property, and that ordinarily the payments to them, contributions to them would be a deduction. Taking both those things as true, the argument is instead that given all of that, your client still can't deduct them for reasons that are rooted in a different provision. So if there's a separate argument there, I'm still missing it. So I don't mean to be.
No, I'm happy to turn to 1.7D because I guess I do think that either way we prevail. But with respect to 1.7D, which limits caps the contributions that a party may make our argument here is Pat is not making these contributions. I take your point, Judge McLeese, that the parties were intending to avoid either party from sort of overstuffing money into retirement accounts that would be separate property. That is not what is happening here. Pat has no control over the Wilmer-Hale defined benefit plan. Those contributions they are paid by Wilmer-Hale to the defined benefit plan. They are for the benefit of each of their partners, but it's determined actuarially. Pat is not on the management committee. He's not on the executive committee. He has no role in the compensation committee. There is nothing that he does to make these contributions. Ms. Carome's argument seems to be that Pat is Wilmer-Hale, which is clearly wrong as a legal matter. They are legally distinct persons, and Pat is not the one who is making any of these contributions.
What do you mean when you say make? Like they're federal, my employer withholds income tax and forwards it to the United States. Do I make those tax payments or does my employer? And are they payments, are they my payments or are they my employer's payments?
So the payments are made by your employer. They are yours. And we're not disputing that Mr. Carome ultimately owns the
So
benefit
if somebody asked
pension.
me, did I, how much income tax did I pay in a given year? You think if I said, well, I paid, if I included the amount that my employer withheld and forwarded, you think I'd be speaking kind of incorrectly as a legal matter or incorrectly as ordinary language if I included all of it? What I really should be saying is, well, I paid, X. My total, the total payments of income tax on my behalf were X. I paid X minus withholding of it and my employer paid the rest. That's what a normal person you think would say, or that's what you think at least a tax scholar would say, or who do you think would say that? Because I it wouldn't leap to my mind to say that.
Maybe an ERISA scholar, if I can, further complicate the level of technical knowledge that's required, because this is a defined benefit plan that has a very specific.
My question was about tax though, but yeah.
Right. But I think, we are talking about this specific asset and the parties have dealt with it specifically. So I believe it is different from either of the hypotheticals that Your Honor was presenting.
I mean, I think the point is the fact that to the extent your argument relies on the fact that the law firm is making these contributions and decides how much it's going to make, and we'll make it whether any partner likes it or not. I don't think that argument really works all that well, because this is all done by agreement between the partner and the firm. When the partner joins the firm, signs the partnership agreement, enters into the, remains a partner, he's agreeing that, all right, here's how you're going to take money that would otherwise be coming directly to me. I'm agreeing to that. So he can't really walk away from responsibility for the payment of a certain amount of what would be his income available to his spouse upon separation by saying, well, Wilmer Cutler made those contributions and I had no say in their making them. Isn't that right?
No, I think I disagree, because this is expressly carved out as his separate property.
That's different, right? No, I understand that argument. If it's carved out in the agreement, then that's why I was focusing. I think if on 1.63 and 5.2, but to the extent the argument which you've relied on appeal is that, well, this is really a contribution over which he had no control because it was decided by Wilmer. I don't know if that argument really stands up.
Well, I think actually the sort of direction of the windfall here would be more towards Ms. Carome. That what Ms. Carome's argument is that for the purposes of the 1.7A earnings obligation, Mr. Carome should have hypothetically put in an amount equal to his defined benefit plan contributions. And so that should have been in the marital account as of the time of distribution, whenever that might be.
Right, from another pot. He should have put it in from another pot.
Right, he should take the cash out of this pocket instead of the Wilmer-Hale pocket, where he can't take that money out, like that money he has.
Suppose he had an agreement with Wilmer-Hale that said, you're going to pay all my expenses in life, and you'll decide how, and you'll take care of paying them, and I won't be able to control you. he couldn't really say that affects how much I have to put into the marital account.
That would be quite the law firm agreement.
Many people have used their law firms in that way. No, not honestly, but
Well, I mean, I guess this is a very different situation. I think that the parties have expressly, contemplated what this would look like. And I think the notion that, Pat has to conjure up the cash to be able to cover what is undeniably his separate property. I mean, the trial court recognized this as, this is not a fair measure of damages.
You also use the word windfall, and I'm not quite sure I'm getting it. So your opponent's argument is your client could have taken a deduction for all this if he had complied with his obligations on the agreement. He didn't. The agreement specifies a consequence. One of the consequences, a set of consequences. One of them is that he gets zeroed out on this contribution.
I'm sorry, which of those obligations is that? That's
I'm not sure where I lost you, so let me try again more precisely. So I think your opponent's argument is, had your client made the required payments into the marital account, your client would have been, under these provisions, allowed to treat as a deduction I don't want to use the word contributions, but the amounts that WilmerHale is treating as compensation and requiring it to be placed in a defined benefit plan, if that's a fair description. But your client didn't make the payments that your client was supposed to. There's a provision that says, as a consequence, if you don't make the contributions, which is, there's a cap on how much of a deduction you can take relating to that kind of economic activity.
Right.
And if you make zero payments or contributions to the marital account, you get zeroed out on that. That's just a consequence of your client's non-compliance with the marital agreement.
So I think, our argument, and I understand that you disagree with
it
me
works
on
the same. I mean, I think you agree that's true. Or do you agree that's true with like 401k payments?
With respect to 401k payments, yes, I would.
So all that happens
true,
with respect to 401k payments, but you say, nope,
But
shouldn't happen. Not a windfall. You're not going to complain about that as an unreasonable windfall or whatever else. That's how that all works.
Right.
For 401k payments. Doesn't work for these, and your theory for why, again, it's not because ultimately that's his property, because that's true of a lot of this stuff. It's instead, focused on the words party making a contribution. And when is it reasonable or optimal, on balance best, to interpret this provision, those words in this provision to apply to like a defined benefit plan. So I keep getting lost in there being some distinct set of points other than let's just figure out what the best reading is of the words, party may contribute as they apply to a defined benefit plan.
Right, and I guess our view is that 1.7D and that cap that would otherwise apply just does not apply to a defined benefit plan. It would apply to a 401k plan, but would not apply to the defined benefit.
And I'm
plan. That's our
sure
position.
that ERISA would preclude this. Not that I know much about ERISA, but I mean, if Wilmer one year said, we're going to put all of your entered into, if Wilmer said, we're going to put all of our partners a share of the profits of the partnership into a defined benefit plan for that year. Your view would be none of those are even contributions. They're not subject to the cap. They have nothing to do with anything. And if that means that there's no money to put in the premarital account, the marital account, that says maybe.
I don't mean to fight the hypothetical, but I don't think that's possible. Under
Understood.
ERISA, that can't be done.
Right. But if ERISA law were changed so that it could be done, then your view is, even though that is treated as WilmerHale understands it as part of the remuneration of your client. It just is, all excluded because of the phrase party may contribute.
I think this agreement was written with the tax law and the ERISA law as was in place at the time, and a change like that, which again, I don't mean to fight the hypothetical, but that would be a very drastic
I think it's
change.
fair. I think that's a totally fair response. So
Okay.
I don't treat that as fighting hypothetical. I think it's a fair response.
And so if there are no further questions on the defined benefit plan, I'll turn to damages and the Rollinger report. And I think, again, the key here is what was the trial judge doing as a matter of damages law? And the court concluded as a matter of law that the appropriate damages framework was what was the amount of earnings that Mr. CAROME should have included in a joint marital account during the damages period, and then subtracting all of the permissible 1.7A deductions, subtracting the permissible 1.7B, each party may pay expenses for the care of each other's children. And then what are the other expenditures that were made by Mr. CAROME during that period that directly benefited Miss CAROME and her children. And this is where the Rollinger report comes in for forensic accounting, financial tracing. These are the subjects on which he was certified as an expert, and he produces this lengthy report. And the goal of the report is to try to identify which are the transactions, what are the expenditures that Pat is making that benefit Miss CAROME and her children, and that should be deducted from the amount of earnings. And I think whether there is a Rollinger report or not, there are still all of these transactions that have taken place. And it is Miss CAROME's obligation as the plaintiff to prove her damages. And so she would still have the same, obligation upon any remand, upon further follow-up, to try to, go through all of these 20,000 transactions. And as the trial court noted, and Ms. CAROME does not contest on appeal, there's no dispute about the completeness of the Rollinger set of financial transactions in that 293 pages of Excel materials. And the same burden would apply on any remand to sort of prove her damages. I think for two reasons.
If I can just stop you for a second, but I want to be, do I understand your position to be that the expert's report was okay because at trial, because it identifies there's all these, here's what I'm taking into account, list of however many transactions there were. And it's Mr. CAROME's burden at trial to prove that those transactions actually occurred and to demonstrate what the basis for them is.
I don't believe it was Mr. CAROME's burden to prove those transactions, but the court.
How could it not be? That's what I don't, in other words, I can see the argument that the expert doesn't have to put up, the expert can simply say, look, this is what I was told. And if it's true, here's my opinion. And that's a sort of a narrow way of reading the expert's report, but I think a perfectly fair way. But then if that's going to be the expert's report, then the burden would be on Mr. CAROME to in some way establish that all those transactions that the expert is taking into account actually occurred.
I don't think
since the expert is not doing it.
So I think the trial court did say that Mr. CAROME has to, produce the documentation receipts to back up these sort of necessary expenses, these expenditures that were allegedly made for the direct benefit of Ms. CAROME. And the trial court says, Mr. CAROME, you only did that in 75% of these cases. And so I'm going to cut off these other 25%. As a matter of law, I think we would still say that Ms. CAROME has the burden of proof on damages. But I think as a matter of what the trial judge did, you're correct.
Right. She proves her damages. Right. She has the burden of proof, but the expert's report is worth nothing if there's no basis for it. And the basis for it, since it can't be supplied or wasn't supplied by the expert, has to be supplied by Mr. CAROME.
Well, and so there are all of the underlying documentation which is provided to Ms. CAROME, the Quicken materials, the Amex statements, the check registers. These are not receipts at CVS or for a dinner, but these are documentation that are provided that form the basis of the Rollinger expert report.
Right, but at a trial, see, one can always ask an expert, look, assume the following facts and now give me your opinion. Okay, so the expert does that. But, and there may be a very good basis for those facts, but the party proffering the expert has to establish that at trial. And I just, and to the extent that that was never done, it's no answer to say, well, you could find it if you look for it in all this discovery. The answer to that, is to say, I don't have to do anything. You've got the burden of proof here. You've got to put it forward at trial, right?
Well, and I think it was done. The expert
Well,
report
that-
does lay out in the 293 pages and in the summary pages.
But those
each
pages are
transaction.
really saying, here are the facts that I'm assuming. You know, my client told me they're all true. Okay, I'm assuming that. But that doesn't get you where you want to go, I wouldn't think, at a trial.
Well, but, and the trial court here did exercise independent judgment over each of these transactions. And there were times where he, after cross-examination, didn't credit what Mr. Rollinger was suggesting. And there were instances where he did, but
Right, can I ask you, like, focusing on the wording of Rule 26 and, like, if you look at either the monthly, I'm not sure which words are, which is a table and which is what, but there are a set of monthly numbers about overall numbers, and there are, hundreds of pages of transactions. With respect to the transactions, does a list of a transaction indicate what the basis is to believe that transaction occurred and how to allocate it or characterize it for purposes of whatever calculations are being made?
Yes, I believe so. We
So,
gave
for
a couple.
example,
Well, we gave a couple examples in our supplemental report. There was the honeymoon expense, lodging for a honeymoon. And then, the memo category and tag are listed out as, this was for a vacation, it was for a honeymoon, it was lodging, and then the source of where that comes from. Same thing for lunch following the civil marriage ceremony.
right. So some are, I'm looking at one now, just a random one that says it gives a check number at least, doesn't really tell you what account it comes from. And then, its tag number is just, doesn't explain why it's viewed as a PAT contribution as opposed to not. But it does provide that. But others of them just say work done and it gives a date.
Mhm.
So like how does that indicate the basis for those conclusions at all? It's like I have no idea why the expert thinks work was done on that date.
I'm sorry, work done.
Well, this is an entry on September 14th or whatever it is. For the description, it names a person. For the memo, it says work done and a date. It puts it in a
I'm sorry.
category, house cleaning, and then it says PAT contribution, and then it says a number, and then it says PAT contribution.
Mhm.
So I would think if I look at that, I have no idea why the expert thinks that happened on that day. Was it based on, you've identified a number of possible, it could be based on, credit card statements. It could be based on an actual bill and receipt. It could indicating payment. It could be an oral assertion by your client. No idea.
I believe you said there was a check number though.
No, on some of them there are, but on
Okay.
this is the example I'm giving here, there's just nothing.
Okay. So I think, this is where it goes more to weight rather than the admissibility of the overall report. I think DC law and the DC cases expressly contemplate that there is the opportunity for a deposition to try to, gain more insight into what these are in advance of trial. And she made Ms. Carome's counsel made the strategic decision not to seek a deposition in advance of trial. So, that I would take the point that there may be individual lines among the 293 pages and 20,000
Plenty of
transactions.
them. That was, there are plenty that are like that. So I don't think it'd be fair to say that that's an unusual illustration there. I haven't done the math of it, but there are plenty that are equally uninformative. And ask you, so if we were just trying to find, you're asking us to conclude, one of the things you're asking us to conclude is that it was not an abuse of discretion for the trial court to conclude that this report met the requirements of Rule 26. It's a big country, lots of expert reports, lots of cases about when they're adequate or not. Have you found any case where any court has said, yep, this was fine, it's true, there's no narrative, all there is just, sets of numbers and, Excel spreadsheets and the like, but that's fine. Have you found any case that's like that?
So I think we have not seen any cases that deal with a financial forensic accounting report like this. And again, that's what he was certified as an expert in forensic accounting and financial tracing. With respect to Mr. Rollinger, he is not an expert on the ultimate question of whether a payment benefited Ms. CAROME or didn't. His job, and I think what he was trying to do to help the court in doing the damages work.
But I mean, that's his conclusion. So if he's not, are you saying he shouldn't have been permitted to testify as an expert to the categories of numbers that are reflected in the report?
For financial accounting and tracing, which is what he was certified as an expert for, of trying to synthesize and present to the court these 20,000 transactions. The ultimate question is for the judge as to whether a transaction benefits or doesn't. Mr. Rollinger provides his characterization.
That's certainly true, but I thought your client, I thought the expert was intended to and did opine, give an expert opinion on those things and gave numbers that were based on those conclusions.
On whether it was an expense based on the documentation that he had reviewed
and whether it was
for Ms. CAROME.
Right.
That's right. Yes, that's right. No, that's the opinion that he's offering. That's absolutely correct. And I think, you know, he's an expert on saying, I've looked at these financial statements and these transactions, and this is what I think. And the judge then makes. On
the issue of harm, leave aside for a minute the question of whether it was an abuse of discretion to conclude that it was adequate. There's obviously a separate inquiry into harm. Do you agree that first, our review on that is de novo, and second, that it's your client's burden to show lack of harm? It's a compound question, so you know, feel free to pull it apart and answer each half.
We agree that we prove that we have the burden to show that there's no prejudice and that it's harmless. I don't think I would agree that it's de novo review. I think the ultimate question is whether there's an abuse of discretion by the judge in declining to strike the expert report entirely.
Well, why is that what the inquiry would be? Your opponent asked in the alternative for, did ask that it be stricken, but also asked in the alternative in the joint pretrial statement that the defects, which I know you don't agree exist, be fixed, and that then there'd be an opportunity to retain Ms. CAROME, another expert, and prepare a responsive expert report that had an opportunity to address, you know, what in Ms. CAROME's view would have been an adequate expert report.
Well,
so why is the world of harm limited to either the trial court would have stricken it in its entirety? It seems like there might have been remedies short of that the trial court's failure to get. If the trial court was wrong that this was adequate, then it may be that the trial court ought to have done, maybe not strike the report, but ought to have done something. And if the failure to do that was prejudicial to Ms. CAROME, then I would think we should be reversing instead of affirming. Do you disagree?
So we don't think it was prejudicial, but we would say that I believe the panel previously noted that Ms. CAROME's expert did have an opportunity to respond to.
Actually, my question is very abstract, and it rests on a premise that you don't agree with. So
right. I
understand you think there was no error here, but assume for a moment that there was error and that the trial court, this was not adequate. And the question is, was it harmful for the trial court to incorrectly conclude, both originally and now? Again, I know you don't, assuming that it's incorrect. Was it harmful for the trial court to have done that? And I thought you had been saying, well, the way you have to look at that is should the trial court have, had to have stricken it in its entirety. And I'm just asking, assume that the following is true.
Right.
I know you don't agree with it, but first it was error to refuse to conclude this was adequate. And second, let's assume that although the trial court was not obliged to, and probably shouldn't have just stricken it outright and said, let's go to trial without the benefit of any information from this expert. At a minimum, it was an abuse of discretion for the trial court to not say, okay, well, this is not adequate. We're going to get an adequate one. And we're going to give Ms. CAROME time to then consult with an expert, get a different expert report, and gear up all the way. If assuming all that's true, which I know is a lot you don't agree with, but assuming that's true, do you agree that we should be reversing because the trial court would have committed an error that was harmful? Or do you think the only kind of harm is if the trial court would have been obliged to strike it in its entirety?
No, I don't think so. I think the trial court's explanation, which we agree with, was, these were raised too late. And I believe as Judge Glickman noted, the trial extended on for 7 months. And so there wasn't a need for a continuance. There
Yeah, why
wasn't
does
a
it
need for
matter
a
that it was
supplemental expert
raised
report.
belatedly, practically speaking, since the trial court even now thinks it was correct? So Ms. CAROME had raised this 10 years before trial. The trial court would have said this is fine. So why does it practically matter when it was raised? The trial court has said, whenever you raised it, you're not entitled to relief.
Well, I believe at the time, the court denied the continuance and denied the opportunity to take a deposition
Right.
in the middle of the
trial
trial.
court that maybe incorrectly, the trial court thought it was fine and still thinks it's fine. So I get a little puzzled about why we should give a lot of weight to when it was raised. If the trial court even now thinks, I don't care when you raised it, it's just not a good objection. We were going to go to trial and always we're going to go to trial on the basis of the report. It was fine.
Well, I think even if you were to review it, de novo, that the explanation that the trial court gave both at the time and in the supplemental findings is the correct one about why these other alternatives, the continuance, the supplemental report were not necessary, and the absence of those did not prejudice Ms. CAROME.
Mr. Lahotsky, we've kept you up here a long time, but if you want to quickly touch on your remaining arguments or rest on your briefs, or I don't know whether you've covered everything you wanted to.
If the panel doesn't have questions, then yield back the time.
Okay.
Well, I guess there is a question to ask you about your claim that on the meaning of the term accrual in the agreement. The trial judge said that in the ordinary course of speech, in effect, accrue has a very simple meaning, and it would apply to the money that was coming to whatever it turned out to be. It would apply to the income that Mr. CAROME would be entitled to receive for 2017 and 2018. Now, what's wrong in your view with the trial judge's, plain language interpretation of the word accrue?
So I think Mr. CAROME's argument at trial and on appeal is that, as of November 4th, 2017, there was, nothing that had accrued as of that time. There was no amount that was known and that was definite. And so it's different from the example of salary, where if someone has worked for 1 week of a 2-week pay period at that time, that 1 week of pay has accrued. But because of the nature of the partnership payments and draws, nothing was known at that time about what the amount would be.
The amount was not known. We didn't, in fact, in theory, it was not known whether it would be a positive or a negative number, or zero. But nonetheless, whatever it was, by November of 2017, Mr. CAROME had a legal claim, a valid legal claim to get his share of whatever it was in 2018 for 2017 up to November, whatever it was in 2017. Well, why isn't that not only correct, but surely what the parties to this agreement must have understood accrued would mean? That's what, it's hard for me to think that somebody reading this agreement who knows I'm the wife of Mr. CAROME, he's a partner at a big law firm. Every year they get most of their income for the year, the following, in the months following that year. When it talks about accrued income, what else could it be talking about?
So maybe what I would say in conclusion is this, we think that the Wilmer partner profits were not accrued, known as of that time. But even if you disagree with us on that,
here's the example that the judge gave. I think the judge gave it. If Mr. CAROME had resigned his partnership in November of 2017, he'd still be entitled in 2018 to receive the pro rata share of the firm profits, right?
Right. So if you agree with us on the during the marriage argument about 1.7A and 5.2A, then I think our view is let's assume that there was a marital account as of November 4, 2017. What was Mr. CAROME supposed to put into that account as of that date that would be those profits? But even if I guess you disagree with us on accrued and you think, no, I think that's wrong. Really, you need to put in 10/12 of the Wilmer profits as of the date of November 4th, 2017. I think that probably further proves the absurdity of Ms. CAROME's argument about during the marriage, because her argument about, owned property with respect to section 5.2 is that as of November 4th, 2017, the parties owned all of the out years, the 2018, 2019, 2020 Wilmer Hale profits, on a theory that that's owned as of November 4th, 2017. And that can't possibly be right. We might lose on the 2017, 10/12.
I suppose
but I don't
another way
see
to
how.
would another way to look at it be, well, he's a partner. His partnership has a value to him. He owns a partnership share, and she should be entitled to a portion of that ownership. It's marital property because he's been working for that, during the marriage. Is that, I don't know if that makes sense or not, but
I'm sorry that
it's just odd to think that when the agreement talks about accrued income, it's not talking about income that's going to ultimately come to him after the separation date, but nonetheless that she has a claim to.
As I've said, you might disagree with us about the accrued point for the 2017 income, but I think that just further proves that we're correct on the 5.2A argument with respect to all of the years of Wilmer Hale distributions up until the point of a divorce that couldn't possibly be included as of that time.
I have two questions, I guess. One is, I know the terminology is different, and this may be part of an answer, but in an ordinary year, and assuming your client had been making the contributions that he was required to, how do you think that should have worked? So he's a partner. He doesn't really know what his compensation for a year is going to be until the year is over and people close the books and figure all that out. So during that first year, are there no gross earnings where contributions need to be made into the marital account, and it all waits until the next January or whenever of the next year, and then that gets paid into the marital account on a lump sum basis? Or do you treat, I know that partnerships have sort of guarantees and people get paid money in between rather than having to just wait till the end of the year. Is all that treated, how would that have operated normally in your view with respect to the obligation to make payments into the marital account?
I'm sorry, did you say in any year or in the first year?
Well, first year, well, leave aside the first year for a minute because I have a question about that. But just in a typical year, so let's say the question is, your client would have an obligation, as would Ms. CAROME, to make contributions. I don't even want to use that word, to place money into a marital account. Based, I think the wording for that provision is gross earnings. So it might be a different concept, but how do you think the marital agreement was supposed to operate relative to this idea that really you don't know what you're getting as a partner at a law firm, and you don't really have accrued income until past the end of the year?
The ordinary course, and I assume that's how it would operate, is that there are monthly distributions. Those would be paid into the marital account. There are then quarterly distributions that usually are in advance of a tax payment, and those would be paid into the marital account as well.
Because those you think would be called gross earnings for purposes of the contribution requirement, but you don't think that they should be treated as accrued income for purposes of this, which is different wording. So it's not an impossible conclusion. I just want to make sure
I don't believe the term is gross earnings, but yes, that's correct.
And then I am interested in the front end, because one of the points that your opponent has made is whatever the logic in isolation might be of the set of points you're making, it's inconsistent with what the premarital agreement did in the first year. Because the premarital agreement, which happens in the middle of a year, rather than treating the entirety of the later partnership determination of partnership proceeds as marital income, instead did a pro rata calculation of exactly the kind that they were advocating and the trial court did at the back end. And their argument is that shows that to the extent there's any uncertainty about what accrued income means, that issue should be resolved unfavorably to you, because it should be resolved in a way that's consistent with what was explicitly done at the front end of the agreement. I'm interested in your response to that.
I guess I disagree with the inference. We think that the fact that they specifically treated it differently doesn't undercut our argument about what accrued means, because as you noted, these are separate provisions. They were expressly carved out at the front end so that the
Well, but
2010
they were carved out.
distributions.
The footnote that carves them out refers to the pro rata for the years before for the months before the premarital agreement went into effect as a premarital asset.
That's right. It does refer to that 9/12, I believe it was, maybe it's 8/12 as a premarital asset. That's right, it does. I mean,
And
again,
that's just not correct. It
we-
was not a premarital asset.
well, no, we do.
Or it was an
We
unaccrued,
disagree
it
with
was an unaccrued premarital asset.
it was an unaccrued premarital asset, and we disagree about the inference that it means for the meaning of accrued in the earnings provision.
Thank you, Mr. Lahatsky. Ms. Khan, we'll give you a few minutes for rebuttal. We'll say 4 minutes.
I appreciate how much time the court has devoted to this. I'll try to move very quickly. On the during the marriage issue, I think this conversation that we've been having this morning has really shown you how 5.2 speaks to almost nothing post-separation, right? I mean, you look at 3.2, which is the provision I earlier cited. I'm not going to read it. I don't have time, but this is the one about retirement accounts referring to during the marriage and before separation, but the survivor being entitled to those benefits if the person dies during the marriage, which clearly means dies post-separation. You've got, so that's an asset right there. That's not going to be covered in 5.2. There's 6.2, which is life insurance payments. There's a lottery ticket example. There are royalties if they own something together. There's accrued compensation itself, right? That's not going to be treated in, it's not a precept. It's arguably not covered by that provision. There's debt. Let's imagine they have a lawsuit by a tenant in a rental property for something that happens post-separation, pre-divorce. What's going to happen to that debt? Like, there are specific things covered in this agreement that are clearly not going to be covered by 5.2. On defined benefit plan contributions, this idea that he doesn't make those contributions, not only does this make no sense, I liked your example of tax payments, but the agreement itself says he makes defined benefit plan contributions at 1.6, JA1 at 42.
Well, I thought that was a little murkier. I thought that's a compound. There are a set of contributions, including them, but also including things.
But they're all DBP. That one doesn't include any 401k. So if you
Which
look at
provision are you talking about
1.6.
1.6.
Sorry, what did I- 1.6. JA 42. So if you look at it, starts on JA 41, it's little 3, and it says Pat's Wilmer Hill defined benefit retirement plan and any other similar substitute tax deferred retirement plans elsewhere, except for his 401k, shall remain a separate property, notwithstanding that he may make contributions to such plans. So it's specifically only about the DBP.
And remind me how the defined benefit plan works with respect to whether there is a payment that is mandatory and implemented by Wilmer Hale, but also a similar non-mandatory component, or is that not right?
He has 2 plans. He has a
Right.
DBP and a 401k.
But everything that goes in the DBP is mandatory and goes through Wilmer Hale in terms of how it's implemented. Is that
That's right. It all goes through Wilmer Hale.
Right.
The 401k plan contributions are also made by Wilmer Hale, but they are, I mean, you know what I mean? They're like logistically, they issue the ACH or whatever, however it's done. But the contributions themselves are being made by Mr. CAROME, attributed to Mr. CAROME on his payroll statements. On the Rollinger report, I wanted to point the court, and really, I literally sitting here, open this up and just look down the page at this report. And if you look at JA2 at 307, on August 31, 2013, there is a charge to Satay Club, which I assume is a restaurant, and Cactus Cantina. You go, these labels, memo category tag, which by the way, I don't even know what those terms mean. I certainly wouldn't have had Rollinger not testified. Most of those are blank. You go to the end, which is his attribution. One is called Pat Direct Contribution. The other is called Other Living Expenses. No explanation for why you would treat one restaurant the same day differently. Beyond that, if you look at the summary tables, there's no entry for other living expenses. I don't even know what that is. It's not defined. And so you can do that page after page of this report. You will not be able to make sense of it. I wanted to speak very briefly to Mr. Lahotsky's argument about accrued compensation. I just want to make 2 points. One is, he says we did not make the argument that accrued is irrelevant because this was also deferred compensation, which is another category of earnings. We did. I want to point you to Ms. CAROME's findings of fact, conclusions of law post-trial dated April 17, 2020 at pages 37 to 38. We cite her expert's testimony, Eggert's testimony, referring to this as both deferred compensation and accrued compensation. So we did make this argument. Not that the accrued argument carries any weight at all. It's not just accrued, it's accrued but unpaid. So it obviously contemplates the payment comes later. The last thing I wanted to talk about is this idea of what happened at the front end of the marriage. This argument captures how deeply unprincipled the arguments Mr. CAROME has been making are. That schedule on which he listed his pre-July earnings was not a schedule of things that would not otherwise be covered. If you look at 1.6, it's a schedule that lists the stuff that is separate property under the agreement. It includes his 401k. It includes his DBP. There was no ambiguity about whether that was covered. It's a list of separate property under the agreement, and it's described as earnings. I think the language he used there was earnings not yet paid. If they were earnings not yet paid, then why are they not earnings not yet paid now? Only because it's a money grab. That's the only reason.
Excuse me, only because
It's a money grab. It's not a principled position. And it's not the only instance in which he took positions like this. You'll see it in Judge Neuter's opinion. Thank you, that's all.
Thank you, Ms. Khan and Mr. Lahotsky for your briefing and your arguments today. We are going to take a brief recess to reconstitute the panel, and we will be back shortly. This case will be submitted, and then next case you can all move up to the table if you wish.
All right. This court will take a short recess to bring on the next item. This honorable court is back in session. You can see it and come to order.
Morning, everyone. We will call the second case, which is Fort MYER Construction Corporation versus Carroll D. BRISCOE. We'll hear first from Mr. Schuler.
Thank you, Your Honor.
The central issue on appeal was, prior to the remand of this case and for an additional finding and remains, whether the Office of Administrative Hearings committed error when they determined that Mr. Briscoe's conduct as a superintendent of Fort MYER did not rise to the level of gross misconduct when he directed a subordinate to falsify time records for a third employee, thereby intending to engage in wage theft from the company. In its memorandum opinion and order remanding, this court directed the administrative law judge to make additional findings as to, quote, whether Mr. Briscoe was or was not motivated by a desire to protect the company's interests, close quote, when he engaged in this misconduct. If so motivated, that could serve as a mitigating factor to what otherwise would be patent gross misconduct under the statute. As reported in her final order on remand, the administrative law judge found that Mr. Briscoe was so motivated and renewed her finding that his actions amounted to simple misconduct, not gross misconduct. We submit this finding was wrong and not supported by substantial evidence. This is so for two simple reasons, grounded specifically in the hearing record. First, Mr. Briscoe testified falsely, or more specifically, the administrative law judge deemed his testimony not credible as to the central fact of this case, whether he did or did not direct a subordinate, Mr. Spada, to the shift scheduler to create and sign a false time card for another subordinate, Ms. Ginyard, putting her in for double pay for a shift that everyone knew she had not worked. Mr. Briscoe repeated this testimony on remand, and the administrative law judge made the same finding, that Mr. Spada and other company witnesses were credible on this fact, and Mr. Briscoe was not. It is simply not reasonable and does not support a finding by this court of substantial evidence to credit Mr. Briscoe's after the fact testimony about motivation to mitigate this misconduct in the face of a finding that he testified falsely about whether he engaged in the misconduct in the first place.
Why is that not reasonable intrinsically? I know, I mean, there is an old Latin phrase about falsus in uno, falsus in omnibus, which used to be at least kind of a permissive inference that fact finders would be told, you know, if you find that a witness has said one thing that's false, you can, but are not required to infer that the witness was false about other things or everything. But it's kind of a disfavored permissive inference even, and you seem to be arguing that it's almost like a requirement that if a fact finder says, well, I really don't believe you about this really important part of your testimony, then it's not permissible for the fact finder to say. But on the other hand, you know, there's a bunch of other things you say that I do find credible. So is your point some general view that it's just never reasonable to believe someone, disbelieve somebody about a really important part of the person's testimony, but then credit the rest? Or is it something that's somehow more context specific here?
It's Your Honor, I think the latter more so than the former. All right, so I'm not arguing that it must be the case that even if it's the central fact of the case, that the fact finder should disbelieve everything that a witness says on all other points. But it does provide a context where there should be more exacting scrutiny of what the witness says and what it means. So the first point is, should he have been believed on his testimony about motivation that he entered into the record after the fact, did not share with the company?
Just to make sure, are you saying that the ALJ made an error of law because there's a legal principle that the ALJ in making the credibility determination here didn't understand, which is the ALJ should have done the following, was legally required to do the following? Well, I find that Mr. Briscoe is, you know, testifying falsely, maybe intentionally falsely about this really important point. I now have some credibility determinations to make about the rest of his testimony, but I need to be aware that I need to have kind of a jaundiced eye about whether to believe him or not. Are you saying that that's a legal requirement that the fact finder has to apply exacting scrutiny and that the ALJ committed legal error by not doing it here?
At the end of the day, Your Honor, I think yes, because her opinion does not suggest that she did apply exacting scrutiny.
And is there law that you're aware of that says that fact finders are required to apply exacting scrutiny in a setting like that? I mean, the closest thing I can think of again are these falsus in omnibus, falsus in uno, falsus in omnibus doctrine, which, as I recall, at least, it was even in its heyday a permissive inference rather than a heightened scrutiny doctrine.
Your Honor, I would agree that it's a permissive inference, but what I think is required under the substantial evidence rule is that the fact finder, well, and let me say it differently, Your Honor. I wouldn't say it's an error of law. What I would say is that this court is permitted under the substantial evidence rule to look closely at the evidence that Mr. Briscoe gave and the treatment that the administrative law judge gave to it. And in our view, accepting it without putting it through that lens of exacting scrutiny as to whether it was credible and whether it supported a finding of motivation. And that's for a number of reasons. Principally that
I think we've skipped your second reason for, you started out saying you have two reasons for asserting that this wasn't supported by substantial evidence. One, you say the credibility finding is no good. It's not supported by substantial evidence. What was the second lead point?
Well, the second point is that even if we assume that the administrative law judge fairly credited Mr. Briscoe's testimony that he feared the company would have closed its doors if Ms. Ginyard had been accommodated for her grievance. This is what Mr. Briscoe testified that he did based on this purported motivation to help Fort MYER. First, he told Mr. Spada to check with in his testimony, he told Mr. Spada to check with a higher level superintendent than himself as to whether Ms. Ginyard should be paid. Second, by his own testimony, Mr. Briscoe did not ever attempt to excuse the act in question, meaning falsifying a time record for the benefit of the company, because he denies that he did that. Third, instead by his testimony, Mr. Briscoe says that he had the company's interests at heart by directing Mr. Spada to have the general superintendent review Ms. Ginyard's claim the same way he had seen another general superintendent hear out a claim by someone that someone was improperly removed from a schedule, adjudicate the case, and then rule in favor of the employee when he found the claim just.
Okay. So it's just your second point just seems like a grab bag of reasons why we shouldn't, why we should not credit the ALJ's credibility findings. Why we should say they're not supported by substantial evidence. You just have it's just a laundry list of things that you think make it not credible testimony. Is that right?
Well, I would say more than a laundry list, Your Honor. I understand the point. What it is going back through Mr. Briscoe's own testimony to see whether it supports the motivation finding. Circling back to the
I'm getting a flavor of a distinct point. I'm curious whether this is what you're trying to get at. At times, what you're saying sounds like the following, which is Mr. Briscoe denied doing the thing at issue. And it's kind of an irrational reconstruction of, maybe even if the trial court, the ALJ could say, well, I think Mr. Briscoe did that. All the rest of his testimony rests on a world that the trial court doesn't believe existed, which is about why he did something that is different from what the trial court has found that he did. And the trial court really couldn't take the evidence about what Mr. Briscoe said about why he did what he did, which isn't what the trial court found he did, and kind of piece it together with what the trial court found Mr. Briscoe did. It's kind of an irrational reconstruction. Is that what you're getting at? Or are you getting at something different?
It's a logic circle that can't be squared.
I mean, why is that though? I mean, let's say I'm late to court one day and I'm speeding and I'm running through stop signs and I'm running through red lights and a cop pulls me over and I say, well, I certainly wasn't speeding. Yes, I was running through red lights and I was running through stop signs. And then I get in front of a court and they say, I don't buy any of that. I think you were doing all of those things, but I do credit you that you were trying to get to court because you were running late. What's irrational about that? I mean, you discredit kind of the heart of my testimony. I said I wasn't speeding, but that's a lie. But, I discredit you, but I understand why you were motivated to do a whole course of conduct, which is I credit you that you were trying to get to court quickly. And that's why you did the other things. And I also think you did the thing that you said you didn't do. That sounds like the situation. That doesn't sound irrational to me.
Well, I think they are inconsistent with each other, Your Honor. And before I get to that, I'll say first that Mr. Briscoe had the opportunity, as the record demonstrates, to make that justification to Fort MYER, his quote unquote family, at the time when his disciplinary event was first reviewed by the company's discipline committee. And he did not make that rationalization.
Can I just make sure I understand how you framed your legal argument? Do you disagree that if we say the finding that Mr. Briscoe was motivated to help his employer, that would be enough to say no gross misconduct here? Do you challenge the ALJ's finding if we say you had a basis to credit him that he was motivated? Is purely being motivated by intent to help your employer enough to cut off gross misconduct?
In the sense of this case, yes.
Okay.
If Mr. Briscoe was really intent on preventing what he thought was going to be literally the company shutting down, and I question whether that's even a credible understanding of the circumstances as opposed to an after the fact rationalization, because again, he did not give it at the time that he was disciplined. He had the opportunity and did not. He only added that, not even at the first hearing on in the case, but in the hearing on remand, after being prompted to say, if you were motivated to help the company, then you may be excused from your misconduct.
I mean, that's a perfectly fair credibility point, and I think we made it to the ALJ. It's a tougher point if the question is, should we second guess an ALJ's credibility determination, given the deference that we generally owe fact finders, and in particular that we owe fact finders on credibility. So I mean, are there cases that you've seen where the fact that an explanation that's accepted by a fact finder was not offered at the first time it would have been natural to do so is so damaging to the credibility determination that under a deferential standard review, a reviewing court is required to, or at least can or should, set aside that credibility determination? That seems like an uphill battle.
Your Honor, I will admit that I cannot point you to a case that with that holding or something along those lines of a holding. But I do think it's fair for the court to say, was there really?
And it's tricky. I mean, human nature being what it is, if someone is accused of having done something wrong, false denial is a natural human reaction. And if Mr. Briscoe is denying that he did it, it gets less natural to say, oh, but if I did do it, here's why I did it. And so, you know, one could imagine that one could assess all this by saying, well, you know, Mr. Briscoe, and I'm not saying you'd have to view it this way. I think you have perfectly good credibility arguments about why you wouldn't necessarily view it that way. But I'm just not sure it's unreasonable to view it as, well, Mr. Briscoe saw a problem. He dealt with the problem. He got in trouble for dealing with the problem that way. He denied that he had done exactly, you know, he kind of tried to minimize what he had done falsely. And he didn't really explain everything. He was more in the denial mode. And then comes a time when he gets more fully into it and he explains why he did it. And, you know, I credit all that. That seems like not the only credibility determination one could make from that sequence of events, but I'm not quite sure I'm yet persuaded that it's so unreasonable that we should be setting aside.
Well, here are some additional reasons, is that what Mr. Briscoe says motivated him to help the company, meaning a prior circumstances he had observed where someone at the company had taken care of an analogous problem by directing that an employee be paid, isn't what he did, right? He didn't do those things. All he did was tell Mr. Spada that he should go to a higher authority.
I'm sorry, what he did, or when you say what he did, you mean what he said he did, or what the ALJ found he did? Because I thought it was sort of
what he said he did. All right. So I'm contrasting what he said he did with what he said motivated him to do that thing. Right. He said that he directed Mr. Spada to go to a higher authority and resolve that. And he said he did this because he was aware that a supervisor in a prior instance that he had observed from a distance had heard out somebody, corrected a timesheet that was unfair, and gotten that person paid. So Mr. Briscoe says, I was aware of this. I was afraid the company was going to be shut down because Ms. Ginyard was going to file a complaint. So I told a subordinate to go to a higher authority. He didn't correct it as a superintendent. He told somebody to do something. He didn't follow up to see whether that person did what he said. And he didn't personally investigate to find out whether there was good cause, as he had said a prior superintendent he observed had done, to make this correction. He didn't sign the timesheet. He directed someone else to do it. All of that shows guilty knowledge on his part, right? He wasn't acting righteous. He wasn't doing the things that this other superintendent, he said, had done to protect the company. He was walking away from a situation because he knew that wage theft was wrong. His testimony is in contradiction to his actions. Even
Well,
if he
again,
did,
I-
even if he did what he said he did.
That's a perfectly good argument to a fact finder. I'm still not quite sure it should carry the day here. I mean, it seems like a fact finder could look at all that and say, you know, I believe Mr. Briscoe on a bunch of things. I don't believe him. I think he did more than what he said he did. What he did is really more like what he saw in the other instance, and he's just trying to minimize his role in it. Now, you know, and there are some differences about the degree of investigation, although he had some personal knowledge, not very detailed, about the underlying circumstance. So I agree, it's not identical, but I take all your arguments, but I'm not sure I am yet persuaded that the way the ALJ cut through this is just in terms of finding what happened is unreasonable. Now, the question of what legal description about misconduct or gross misconduct should be given to what happened, if you take as a given what the ALJ found, you know, that's another topic, but
That's the topic I was going to segue into. Suppose we accept all the factual findings, including the credibility determination by the ALJ. Are we therefore bound as a matter of law to say that this was not gross misconduct? Or do you still have an argument that even if his motivation was, as the ALJ concluded, it was still gross misconduct?
Your Honor, I don't think that you are legally bound to accept the ALJ's legal conclusion that mitigating circumstance is sufficient to overcome gross misconduct, because the misconduct itself could still trump the reason for him believing he was benefiting the company.
Oh, can you, because I thought I asked you a similar question earlier and you gave me the opposite answer, that yes, you were kind of hinging everything on this credibility finding, but maybe I misheard you. Could you point me to where in your briefs or supplemental briefs you've made an argument that if in fact Mr. Briscoe was motivated by a desire to help the company, we should still overturn the ALJ's conclusion? Because I don't recall that argument being made. The supplemental briefs, as I read them, sound like everything is hinging on, can we credit this factual finding that he was motivated by a desire, or should we set aside that factual finding that he was motivated by a desire to help Fort MYER? And I don't see the alternative argument of, even if he was, you still need to reverse here because ... I'm not sure what that argument is.
Well, I'll agree, Judge Steele, that that's a fair characterization of the supplemental brief. It does not directly make that argument.
Do you think it's in the opening briefs?
Oh, no, sir. Well, because that
Right.
question wasn't raised in the opening briefs. But I think it flows from the fact that Mr. Briscoe's conduct was inconsistent at best, in terms of how he acted on his motivation. Even if we accept that he was motivated and he had some fear for the company, he did not take the steps, and this is in the briefs, that would have been consistent with his training, which is to take the question of whether there was discrimination against Ms. Ginyard to a higher supervisor or to human resources. And it is in the record that he was trained to do that. So he didn't act consistent with his training. And instead he exacted a self-help remedy by directing a subordinate to do something he would not do himself. And I think that trumps whatever motivation that he had, even in the administrative law judge's view, to help the company, because he wasn't taking steps he knew would help the company.
well,
Meaning cutting off a source of
yes,
discrimination.
I understand.
within the company.
I think the way the ALJ was looking at it on the question of gross misconduct, at least, is, and these are some other findings, not just motivation, but also that he had seen analogous self-help that wasn't really the way things would be done if everybody is crossing their T's and dotting their I's. And so he thought, this is kind of the way, I know what training is, but there's the real world and what I've seen in the real world. And so there's a problem here. I'm concerned about it. I don't want to lose my job. I don't want this company to be shut down. Again, this is on testimony that the ALJ is crediting, whether correctly or not. I've had prior concerns about this company and discrimination. And so I think I've been told that there are real concerns about the company being in trouble. I'm going to try to not make a big deal of this. I'm going to take the more informal approach, maybe not the training, full compliance with all requirements, but more the real world examples of what I've seen. That's the way the ALJ seemed to be looking at it for purposes of gross misconduct. And if you think that it's just so obvious, I have no idea whether this ended up helping the company or not, really. I don't know that anybody's made a finding about whether it did or didn't help the company, the shortcut he took, or whether it would have helped the company if nobody had raised a concern about it. Not sure. So I'm not sure that we're in a position to fully assess that question. But why is that gross misconduct? Your opponent argues it's not misconduct at all, which is something we should discuss at some point. But why is it why is that gross misconduct if that's the view of the facts the ALJ permissibly could take, which I know you don't think is the view of the facts the ALJ permissibly could take?
Because the substantial evidence doesn't support the fact that Mr. Briscoe did what he had observed other superintendents do in the past that he claimed motivated. Right? He didn't investigate. He had the ability to determine, he admitted, whether Ms. Ginyard was on the schedule in the first place and therefore could have been unfairly removed. He did not confirm with her that she considered it to be discrimination as opposed to favoritism for a friend of the scheduler, because he knew both of those ideas were in play. And as I said, he did not take the further step of endorsing his corrective action, as he had seen other superintendents do, by signing off on it himself. He hid from the action, right? He went in the opposite direction. He said, I'm walking away from this, but she's going to get paid. Right? That isn't what he had seen others do, which he believed to be in the interests of the company. He did something different. And therefore, I don't think there was substantial evidence to show that his true motivation was to help the company. Or if it was, he did it in such a backhanded way that it should still be considered, it shouldn't be considered to completely absolve his wrongful conduct, because he deprived the company of an ability to determine whether in fact there had been discrimination, instead of his assumption that there might have been, not even bothered to vet by asking Ms. Ginyard, which he admitted, whether she believed she had been discriminated against based on her race.
Do you agree that once we settle what factual conclusions are supported by substantial evidence and therefore what we're working from, that the question of whether to call that gross misconduct or misconduct at all is something that we decide de novo without deferring to the conclusion that the ALJ reached on that topic?
I would disagree that the question of whether there was misconduct at all is in play, because that wasn't challenged on appeal by Mr. Briscoe. So it's a question of was there simple misconduct or was there gross misconduct?
It's in the supplemental briefing. The
Well,
response brief at page 20, or do you just mean they didn't cross petition?
Yes, I'm going to the cross petition circumstance.
Well, did you, that's an argument you could have made, but I did not see that in your supplemental reply brief, for example. So you file a supplemental brief.
Yes, sir.
Mr. Briscoe files a supplemental responsive brief and argues, ALJ was correct as far as it goes on gross misconduct, but while we're here, in fact, we think that there was no misconduct whatsoever. And you file a reply brief, and you could have made the point, which would have been an interesting point to research and discuss, that the failure to raise that in an initial cross petition foreclosed it from being raised now. But I didn't see that in your supplemental reply brief. Was it there and I didn't see it, or?
No, sir. We did not argue that point, but in the cases cited by appellee, it is patent that the rule that applies is that there must be some form of I wouldn't call them extraordinary circumstances, but there must be circumstances that would warrant deviating from the basic appellate rule, which is that an appellee cannot challenge or cannot ask to undo a part of a lower court's ruling unless he appeals from it.
What's awkward about that, I guess, is that there is also an equally, maybe equally, quite well settled appellate rule, which is ordinarily points made for the first time at oral argument are too late. So we kind of have, it's a little awkward for you to say, well, my opponent failed to make an argument timely. Now, it's true, I didn't bring that argument timely, but you should excuse my untimeliness, but not my opponent's. So it seems a little awkward to be raising that for the first, an argument of that character at for the first time at oral argument.
Understood, Your Honor. As I say, our position was in reliance on what's a basic principle of appellate law, which is that if you haven't appealed an order, then the court should not, I can't say may not, should not consider an attack on an aspect of the lower court's decision that was not raised by an appeal notice.
That was a quite reasonable distraction from a standard review question that I was posing to, and I'm not sure I may have missed it, but my question was, assume we figure out what the historical facts are that are supported by substantial evidence. And the question is, okay, now that we know that's what the record could reasonably support as to exactly what Mr. Briscoe did and why. And then we have to decide at a minimum whether it's gross misconduct or not, perhaps also whether it's even misconduct. Do you agree that our review of that is de novo and we owe no deference to the ALJ's labeling of that conduct once you know what it is and reasons once you know what they are? Or do you think that there's some kind of deference that is owed on the attachment of a label of gross misconduct or misconduct to the facts once we know what they are for purposes of our review?
No, sir. I think the decision of whether there was misconduct and whether that conduct rises to simple or gross misconduct is de novo. I'm out of time.
Thank you. Unless my colleagues have further questions, we will give you some time in rebuttal, and we will hear now from Ms. Steele.
Thank you and good morning. Rebecca Steele with legal aid of the District of Columbia, representing respondent Carol Briscoe. This court remanded this case after the first round of briefing so that the administrative law judge could make factual findings on Mr. Briscoe's motivations. Here today, we have the benefit of those factual findings, which are entitled to deference and which include the fact that Mr. Briscoe was motivated to protect his employer. The fact that Mr. Briscoe believed he could take the steps he did because, and I quote from the final order, he had seen management correcting a problem by paying the employee, end quote, on multiple occasions in the past. And that Mr. Briscoe believed Kendra might file a discrimination complaint and that this risked shutting the company down entirely. As factual findings supported by substantial evidence, the ALJ's determinations are entitled to considerable deference from this court. And the finding that Mr. Briscoe acted to protect his employer is outcome dispositive.
Why is it outcome dispositive? Suppose he had in the middle of the night gone into the treasurer's office and said, I've really got to make it up to this employee, and had just stolen $1,000 out of the till. And the following morning, brought it to her and said, look, here, I'm making it up to you. Would you still be saying that's not gross misconduct?
We wouldn't, Your Honor.
How is this different?
So this court has consistently relied on an employee's intent in defining.
His intent in doing what I've just said is exactly what the ALJ, in my hypothetical, is exactly what the ALJ found it to be. He
Right.
wants to save the company.
Right.
So it's all right for him to go in the middle of the night and steal $1,000 out of the till?
It's not. And that's because of this court has the ability to pose an objective standard of reasonableness to limit intent. This court hasn't had the occasion to do that in the past because no cases have required it. And this case similarly doesn't require it. But in order to prevent a kind of slippery slope whereby any well-intentioned employee can do anything at all to benefit the employer, there could be an objective reasonableness standard imposed on top of
I
this
assume there is. I
intent.
assume that if you break the law, it's hard to argue that that's not gross misconduct. if assuming it's a material breach of the law. And I'm just wondering how what he did here is different from just a midnight, requisition of the necessary assets.
So what Mr. Briscoe did here was consistent with what he had seen Fort MYER do in practice when similar issues arose, which was paying employees for hours not worked. Now,
But what Fort Myers, I think, is saying is, he should have known, if he really saw that, I think they probably doubt it, but if he really saw that, he should have known that that was wrong. It's stealing.
this is not theft. That's because there are numerous circumstances, both in practice and the
Well,
ALJ. did-
technically, it's a different crime, but it's still a crime.
Right.
Right.
This is not criminal, both because it's supported by what Mr. Briscoe saw in practice and also because there are numerous examples in Fort Myers' own paving agreement, the contract with employees that allow payment for hours not worked. So Fort Myers' argument that by definition, payment for hours not worked is a crime is untrue. But even beyond that, this court, to your earlier point about surely something criminal would surpass the objective reasonableness limit. That is not the case under this court's finding in previous cases, such as Jadella, where that's Jadella versus District of Columbia Department of Employment Services. In that case, there was no dispute that the actions that the claimant took constituted a fraudulent conduct. But the fact in that case was that he didn't have the requisite intent. So even if conduct is potentially criminal, and in this case, it's not, that alone does not determine the outcome that it would be gross misconduct. And I think it's helpful here to turn.
Hold on one sec. Suppose his intent here had not been, suppose his actions were exactly the same, but his intent was not what the ALJ found it to be. His intent was just to do this woman a favor. Maybe she'll do him favors back in return. Whatever his motivation was. And he does exactly the same thing. I think you'd be saying under those circumstances that, well, he committed a crime
I think
of some kind.
not necessarily.
No? Oh, okay. I mean, I
I
would
think-
have thought that falsifying records of payment for somebody who didn't earn the payment would be presumptively, theft or some theft type offense, fraud or what have you.
If I can clarify my response, if this was a situation where he knew it was inconsistent with Fort Myers policy, knew she did not work, that would present a much bigger problem that I don't think is analogous to what happened in this case, where the ALJ did make a factual finding that he was motivated to protect his employer.
See, motive doesn't normally change whether something is, a crime, for example.
Intent.
It's not like intent. You have to have an intent to steal or to whatever. Your reason for doing it, what motivates you generally doesn't, I think, change the wrongful or criminal, that might be a better word, character of the act. And here, he may have been motivated by reasons that we might say, well, they're, okay reasons. He's taking a decision upon himself that really belongs to somebody else, but let's put aside that. It still seems to me that what he's done is a form of theft. And
So-
not in principle different from a more efficient way of doing it, which is going to the till in the middle of the night and taking the money out without anybody else knowing about it. And that's troubling to me.
I think a crucial difference from that circumstance and what happened in this case is that what happened here is very similar to what the procedures Mr. Briscoe witnessed, and it's also very similar to Fort Myers' own policies. So if I can turn to the paving agreement, which was submitted as Exhibit 3 in the second evidentiary hearing, there's a provision under Article 2A that reads, "No employee shall be denied employment opportunities based upon the number of hours that an employee has accumulated in the course of a work week. In the event a crew is working and an employee within that crew is denied employment based upon accumulated hours, then said employee shall be paid for the number of hours worked by the substitute." So this is one example, and I'm not suggesting that it maps on perfectly, but it goes to the point that Fort MYER frequently contemplates payment for hours not worked. It's another form of compensation. It's not theft or misappropriation of resources by definition. There may be some circumstances like where you're describing where someone knowingly goes to the till, takes out money for their own benefit with no assumption that it's consistent with company policy, but that's not what we see here.
Yeah,
And
but I assume that process, they might have a policy that allows annual bonuses as well, but doesn't permit Mr. Briscoe to unilaterally determine who's going to get an annual bonus. So saying that, well, sometimes they pay people for hours that are not worked seems to kind of skirt the relevant question, which is, well, is that Mr. Briscoe's call or somebody else's? And nothing about that policy would suggest to me that it's Mr. Briscoe's call. And if it's not, then it still seems like it's a pretty clear violation of the rules.
Mr. Briscoe did see other superintendents do it, but even if it wasn't his call, the standard here isn't, did Mr. Briscoe take the steps he should have? It's not even, did Mr. Briscoe do something wrong that justified his termination? The question is whether what he did rises to the level of misconduct as defined by the statutes and regulations. And that does require a level of intent that is not present when we're not evaluating whether what he did was consistent with policy or whether it constitutes a crime or those other questions. It's a very specific and narrow question as to whether it constitutes misconduct. And this court has always held that that requires intent to harm the employer, which we have a factual finding entitled to deference.
Are you just talking about, because this is a question about your supplemental brief, where you say there's not even simple misconduct here. And I read your brief to suggest that if there's not an intent to harm the employer, you don't even have simple misconduct. Is that right?
That's correct.
I mean, that kind of goes back to Judge Glickman's hypothetical. I mean, here's another one. I'm a restaurant worker and a health inspector comes in and sees, rats in the area. They're going to shut down this restaurant if I don't do something. So I clock them over the head. I tie them up and I throw them in the freezer for a bit and just to try to get ahead of the situation. Undoubtedly to help my employer. But that's not misconduct because I lack an intent to harm my employer.
That I think is a very different circumstance that's from what you're describing sounds like misconduct. And the reason that we can differentiate even though they both have no intent to harm the employer is imposing an objective reasonableness standard. I
don't know how far that gets you though. I mean, if it's Mr. Briscoe has no business making the call of whether or not there's been discrimination and authorizing people to be paid for hours that they didn't work. Why would we hold that was an objectively reasonable thing to do?
The only instance where this court has contemplated a finding of misconduct without the requisite intent, which would be what would be happening if a misconduct finding were to be made here, is in the context of gross negligence. And I think it's helpful to look into some of the language that the court has provided on that kind of reasonableness limit. And what the court has said in Capital Entertainment Services v. McCormick is it has to be highly unreasonable conduct involving an extreme departure from ordinary care in a situation where a high degree of danger is apparent. And that's on page 23.
But that's for gross misconduct. And so if you take, I thought you said.
My understanding is that's the intent requirement that's relevant to all misconduct findings. Because negligence is neither gross nor simple misconduct.
That's the case of negligence. Here we're talking about intentional conduct.
The reason I think negligence is a helpful example is because the only other circumstance where we might find misconduct without intent. There's been no other scenario where the court has found, and there have been scenarios where what happened looks really bad. For example, Lynch v. Masters, a security guard left a loaded gun in a publicly accessible restroom. But because there was no intent to harm the employer, even though everyone would recognize that that is not something that a security guard should do, the security guard didn't do what her employer wanted. Nonetheless, there was no misconduct because there was none of that requisite intent.
Well, could I make a distinction here that when you say there was no intent to harm the employer, I wonder if we should be taking issue with that. He had two intents, one could say. He intended to help the employer by not letting the employer be shut down by the anti-discrimination police. I don't know what he was thinking, but whatever. But he also intended to harm the employer by taking money out of the employer's till and by stealing it. That's a harm. he intended to harm the employer in the service of avoiding a greater harm, you might say. Well, I don't know if that's the same thing as not having an intent to harm the employer.
Given that Mr. Briscoe's understanding, I think that there was not intent to harm the employer. And let me provide more details as to why I don't think that taking the money was intent to harm in service of avoiding a greater harm. And that's because Mr. Briscoe understood and the ALJ found that he was acting in a way that was permitted by Fort MYER policies. He understood this to be a circumstance where it was appropriate to pay employees for hours not worked. And whatever sum of money would have been paid for those 10 hours would have been equivalent to an authorized payment under his understanding. And for that reason, there was no intent to engage in wrongdoing. And the ALJ did specifically find that his only motivation was to protect the employer, and there was no finding of intent to engage in wrongdoing, which
So you're saying that the ALJ's findings have to be understood as this employee had the authority to make the decision to take the employer's money and pay the employee in these circumstances based on a belief that it was appropriate to do it, whatever, that she should get the money for some reason or other. Do the findings really go that far?
The findings go not to the content of the policy, but to Mr. Briscoe's understanding of it.
Understanding of it,
Yes.
right.
And would you agree that if that understanding was unreasonable enough, conduct like this could be viewed as either misconduct or gross misconduct? And as a hypothetical, imagine that what Mr. Briscoe had done here, quite different from anything that anybody had ever done before, was to direct the timekeeper, Mr. Spiro, I think, to give the worker an issue a year's salary, cut her a check for a year's salary, and assume that an ALJ looked at that situation and said, "Wow, I believe Mr. Briscoe when he says that was trying to help the employer, but that's just not, I mean, no one could possibly have thought that that was anything that the employer would have authorized or allowed. It doesn't fit reasonably within any policy, doesn't fit reasonably within anything he's ever seen before. So that's just not a bad motive, but a means that is maybe criminal, probably not lawful, and wildly unreasonable." Would you say in that hypothetical, no misconduct, but not gross misconduct, gross misconduct?
It's obviously a very fact-specific inquiry. What you're describing sounds like it would rise to the level of misconduct. And that's because, again, of that objective reasonableness standard.
And so is it therefore for us, is it fair to summarize this by saying that it's not enough for us to say no misconduct or no gross misconduct, to simply agree with the ALJ's determination that the motive was benign relative to the company's interests? There also is a question that could bear on whether there's misconduct or gross misconduct, which is were the means picked in the subjective belief by the employee that the employee was protecting the employer's interests, were they sufficiently contrary to employer's interests or policies and sufficiently unreasonable as to give rise to misconduct or perhaps even gross misconduct? That we have to have some assessment of whether those, taking as a given that Mr. Briscoe believed that what he was doing was in the employer's interests and within the realm of the kinds of things that similar problems have been remedied. We have to, in order to find no misconduct, we should be also considering whether that belief was so unreasonable that it nevertheless the conduct was misconduct.
No, Your Honor, I don't think you need to breach that question in this case, and the court has never applied it before. Intent has always been enough. The reason I bring up the objective reasonableness standard is because you can envision, and you have raised circumstances where that would lead to disastrous consequences based solely on intent. So the reason I bring up the objective reasonableness is to provide a limiting principle, but it's not one that this court has applied in the past. And I don't think that it's one that it needs to apply in this case to go into a deep objective reasonableness inquiry, because we know that what he was doing, he thought it was consistent with the policies. The ALJ already found
Well,
that.
that sounds a little circular. That sounds like don't worry about it because it was reasonable. So that means maybe we should just say it's reasonable if we agree with you on that topic. But if it's a potential limiting principle, then I would think we would either need to say, well, it's actually not a limiting principle, or it is potentially a limiting principle and then assess how this case fits within it. or maybe decide the question and then also assess how the case fits in. But I don't know how we could say it's a possible limiting principle. We're not really sure how this case would fit in with that possible limiting principle, but we're going to rule in favor of the claimant. That seems like we wouldn't be necessarily doing all the homework that we logically should be doing.
Right. I think the reason that is a possible permissible outcome here is because there have been circumstances where claimants have done objectively things that are inconsistent with their employer's interest without the motivation, and this court hasn't had cause to impose a reasonableness.
Well, I take your
principle.
point, and maybe this is a terminological point about whether the requirement is reasonableness or something more than that to be misconduct. Because, I mean, to me, if you look at the regulations defining what's misconduct and what's gross misconduct, they seem pretty draconian and pretty easily triggered. If you look at our cases, they definitely seem to be more demanding. And if part of your point is some things that the court has concluded were not misconduct or gross misconduct seem like they weren't reasonable conduct. And so there can't be a general requirement that to not be misconduct, the conduct has to be objectively reasonable in some way. That seems to me correct. But so that if it's a limiting principle, it may not be exactly a reasonableness principle, and it may be more of a heightened unreasonableness of some kind beyond kind of, well, okay, this wasn't quite right. It wasn't perfect compliance with what the employer's policies are. But, and maybe it's not even reasonable, but it's, it was in good faith and it's not that bad and we're not going to call it misconduct. I think our cases, some of them might reflect something like that. But that's really more about how exactly to characterize such a limiting principle, if there is one. Less, I mean, I take it, if push came to shove, you would concede there must be that kind of a limiting principle. I mean, if the way Mr. Briscoe had subjectively decided to protect his employer's interest was by murdering the employee so that she couldn't bring a claim, well, obviously that's going to be gross misconduct. And I assume you would concede as much.
Yes.
Right. Even though assuming, however irrationally he thought that would benefit his employer, doesn't matter. There comes a point when it's just so outrageous in means that it's going to be not only misconduct, but gross misconduct.
Yes.
Another facet of his conduct here was that Mr. Briscoe did not sign the paperwork himself to arrange the payment that he thought was deserved. Instead, he ordered, if you'll allow me to use the word ordered, I forget the man's name now, actually, but he ordered a subordinate, clearly against the subordinate's wishes. The subordinate was reluctant to do it. How do you factor that into this?
I think that question is a preliminary question that ultimately goes to Mr. Briscoe's motivation, and that's a factual finding. So we don't know on the record exactly why Mr. Briscoe took the steps that he did. But we do know that the ALJ found he thought he was acting consistent with Fort MYER policy based on what he had seen in the past. The reason it would be relevant why he took that specific step compared to doing it himself goes to intent. And that has already been disposed of by the ALJ.
It goes to a number of things. I think it goes to the honesty of his professed belief that he was doing something that his employer basically would approve of. It also increases the seriousness of the misconduct because he's jeopardizing somebody else by inveigling them to go along with the scheme. And I wonder if we should be taking that into account and evaluating whether objective reasonableness or seriousness of the wrong, or however one wants to frame it, has been shown here.
I don't think that should be factored into evaluating the level of misconduct or the seriousness.
Why
And that
not?
the reason is because a finding of misconduct can only be made based on the reason for discharge provided by the employer. And in this case, that was misappropriation of FMCC resources, time theft. It didn't have to do with the relationship between Mr. Briscoe and Mr.
Oh, that's a
Spada.
fair point. In other words, because the other employee was penalized as well. But the employer didn't think to include this in the bill of particulars, as it were.
Yes, and because it wasn't included by the employer, it's not permissible at this level to take that into account when evaluating the level of misconduct.
Well, I'm a little unsure about that. I don't know that it has to be like a separate gravamen of a description of what the misconduct is to be available for consideration in trying to figure out whether the act that was listed has the relevant severity. And your opponent, I think, tries to make it relevant in a third way. I'm interested in your response to that, which is the idea is if we are assessing at some level whether the means that Mr. Briscoe took to advance his client's interests were reasonable or so unreasonable as to be misconduct, or however you're going to formulate this additional possible inquiry, how similar it is or how different it is from what has been seen before is potentially relevant. And your opponent argues, well, the prior examples didn't involve telling somebody else to fill out a form inaccurately. It involved like the manager taking responsibility and saying, okay, this is my call, this is my job, I'm going to take care of it. And so your opponent argues that's relevant to how unreasonable or reasonable or somewhere in, above or below that line, your client's conduct was here.
I think what Fort Myers is suggesting that this is time theft, and their primary issue isn't with who signed the ticket, it's with the fact that she was paid. So I think getting into the details is not necessary to resolve the question. I think the differences may be relevant, but again, that's a factual finding. Another important difference is that Mr. Briscoe wasn't involved in that shift at all. No one has suggested that he was responsible for that shift, whereas the supervisor that signed the other ticket, it seemed like that was their shift, is what the record suggests. So there are numerous differences, but the key is that it was sufficiently similar, that the fact that in both cases, time tickets were authorized for hours not worked to resolve the issue, such that we don't need to get into the details of distinguishing them. And again, that goes to the question of his motivation. And the ALJ did find that he was acting, he thought, consistent with Fort Myers policy. To return to some of the factual issues that came up during Fort Myers counsel's argument, there was this idea that it's not that the facts are contested, and that given that the ALJ found him not credible on one point, none of his story makes sense. But I think it's important to remember that the two versions of events offered here are not worlds apart. It's just a difference of whether it's not as if Mr. Briscoe is saying, I never even raised the possibility of paying her, but if I had raised it, here's why I would have. This is a situation where he concedes that he brought this up, and it's really a matter of the exact phrasing that he provided to Mr. Spada. So to suggest that that discrepancy undermines his entire story is not logical, but it's also, as this court already discussed, not consistent with the precedent on the fact that an ALJ can make an adverse credibility finding on one point and yet credit the testimony, the rest of the testimony, and that the court found in Hamilton v. Hojage Foods. I'd also like to speak to the point that my opponent made arguments that Mr. Briscoe didn't act consistent with his training. And again, that's a question that is not what's before the court today. The question is whether what he did rises to the level of misconduct. For the reasons we've discussed, he didn't have the requisite intent to meet not only the level of gross misconduct, but also simple misconduct. And that's because intent is a threshold requirement for misconduct. It's not a factor used to differentiate between gross and simple.
Can I just ask a question about what you're talking about as an objective limiting principle? I know we're returning back to an old topic. There are two very different ways you could articulate it. I'm just not sure which way you're thinking of it. One is, well, there is some kind of backstop of the actions that the employee took need to be objectively reasonable. The second way of thinking of it is, well, one would need to be, their belief that they're helping their employer needs to be objectively reasonable. And I think those could be two worlds apart. In one case, we could say, well, what Mr. Briscoe did here was certainly not reasonable. But could he believe it was to the benefit of his employer? Sure. And so the tests sound different to me. Which one do you think is the limiting principle?
I think if this court were to impose a limiting principle, which it hasn't done in the past, the first test that you articulated would be more consistent with equivalent standard the court has imposed in the realm of gross negligence. Because as you suggested, someone could have a reasonable belief that ultimately is very harmful to the company. I think it's the conduct itself that would be relevant to that inquiry for the most part.
Okay.
Can I just want to interrupt for 1 second? I apologize, but I can't remember what you said. You took the first one, and right now I can't remember which was first and which was second. So I just want to make sure I understand your answer. So how would you formulate it as what is needed, if anything is needed, is reasonableness as to belief of assistance or operating the benefit of the employer, or what I think maybe was the second one, which is kind of objectively reasonable conduct. The conduct as a whole was reasonable. Were you saying the first, as I just did them, or?
I think you can consider both, but that there would be a place to consider the conduct itself. But I also want to recognize that in no other misconduct case has the court found the need to articulate this limiting principle, and it's not necessary to do so here. I raise that point as a stopgap measure in the event that a future case presents someone who does murder a competitor, the type of examples that have been brought up today. But in response to your question, I think there would be a place to consider the action itself in addition to the subjective motivations.
And then one question about the extent to which your new simple misconduct, that this wasn't even simple misconduct argument, is properly before us. In addition to not cross petitioning on that question, in your opening briefs, you conceded. I mean, it's quite clearly said, we're not challenging the finding of simple misconduct, and that's at page 14. I can't imagine we've ever previously found in a case where somebody didn't cross petition on an issue and expressly conceded it, nonetheless considered it because of sort of a late breaking supplemental brief argument. I mean, do you know a case like that? Why do you think this is properly before us, having not just failed to cross petition, but sort of expressly waived the argument?
I think the reason this case is different is because the intervening remand by this court asked for a specific fact, which was his motivation. And upon receiving that fact, we now know that there's a clear there's a clear legal error in the record as it stands that didn't exist at the time that we filed our first brief. Fort Myers spoke to the issue of this, all this new information coming out in the second hearing undermines Mr. Briscoe's credibility. I think it's important to note that that testimony was kept out of the first hearing because the ALJ sustained Fort Myers' own objection to Mr. Briscoe offering testimony on this issue. So all of this new information suggests that as it stands before us, a finding of misconduct where there is no intent is inconsistent with the legislative purpose. And I don't have a case that presents.
Well, I'm sorry. No, I don't mean to cut you off, but I wanted. Go ahead, finish your sentence, please.
I was just going to conclude that I don't have a case that presents this exact circumstance, but we do know that the court has recognized that the rule is non-jurisdictional. It's a rule of practice, and the argument against its application here has been forfeited by Fort Myers by their failure to raise it in the brief. But beyond that, the statute, I can provide some additional examples on why this statute in particular necessitates it and how the court has waived rules of practice in the past, but I first want to turn to your question.
Well, I'm moved to return to the subject of intent a little bit because it keeps coming up. And I think my understanding may not be the same as yours. I don't understand it to be the case that an employee has to have the intent to harm the employer in order to commit misconduct. And do you agree with that?
No, Your Honor, I believe the cases of this court suggest that the intent to harm the employer or intent to commit wrongdoing is a prerequisite to a finding of misconduct.
I think, when I think back to the cases involving negligence, one of which I may have written, so I may be on the hook here. But my recollection is the point is the negligence cases turn on the fact that the employee wasn't really intending to do what the employee did that was so bad. But here, what you have is an employee who was intending to do what was improper. And what the employee should have known was improper. And that's rather different. And again, when we speak about motive, well, his motive may have been it's hard to know, don't know what the exact word is, what word to apply. His motive may have been one that is not criticizable. It might have been a good motive, but that doesn't really matter in a way. If he shouldn't have done it, and he should have known he shouldn't have done it, and he intentionally did it, that's really enough. And of course, it is an intent in this case, in part, to harm the employer, at least in one sense. He's taking money out of the employer's cash register. I would have thought that's enough for at least simple misconduct, if not, gross misconduct. So I have a little trouble on, with that as the prelude, I have a little trouble understanding the argument, not even simple misconduct. Even accepting everything that is said about his motive.
So I think that the case law suggests that it's not sufficient for Mr. Briscoe to have intended to have this conversation about Ms. Ginyard's pay. The intent is specific to wrongdoing. And I think that Jadala, again, the District of Columbia Department of Employment Services, 476 A2D 671 is a helpful case here, because in that case, everyone conceded that the employee acted intentionally and that the results of those actions were the commission of fraud. But because he didn't have the intent to engage in fraud or the intent to harm his employer, specifically the latter, actually, that wasn't necessarily enough. And I think Larry, the National Rehabilitation Hospital, is also helpful here. This was a case where relating to absences, and the court recognized that she acted deliberately in the sense that she deliberately did not go to work that day, but that wasn't sufficient to meet the intent requirement. And that site is at page 183. So I think it is specifically the intent to engage in wrongdoing. And the reason for that is that this court has consistently held that basically a bad judgment call or a mistake isn't enough to disqualify you from your presumptive eligibility for safety net benefits. It actually has to be an intentional violation of the employer's interests, because the statute is remedial in nature and strongly privileges the presumption of the eligibility for benefits wherever it can be applied. So I think the intent.
And you don't think the record here doesn't show an intentional decision contrary to the employer's interests? When it shows a theft.
I don't think so, Your Honor. I think any decision point has kind of two paths. And in one way, you might be benefiting the employer in some respect, but not in the other, and vice versa on the other. So the fact that he was intended on the whole he was motivated on the whole to help his employer is most important. And he didn't perceive what he was doing to be theft. We would argue that it was not theft under the circumstances, so that and again, the fact of actual harm to the employer isn't, if we return to Lynch v. Masters, the gun was left in a bathroom. That could cause harm to the employer, but that's not sufficient to make a finding of misconduct. And again, that's coming back to the intent to engage in wrongdoing.
So in a sense, it really does come back to that limiting principle issue of the reasonableness of the employee's thought process and conduct.
It could. And again, I emphasize that this court hasn't felt the need to articulate such a limiting principle in the past. I don't think this case necessitates one, but to the extent that there is this objective reasonableness imposed on top of the subjective intent, what Mr. Briscoe did here was objectively reasonable and doesn't rise to the level such as what this court has imposed on the gross negligence side of things, because he was doing something that was very consistent with what he had seen other superintendents do. He was acting in a way that appears to be contemplated, at least in certain circumstances, by the agreements. And he believed, as the ALJ found, and again, these are factual findings entitled to deference, that he was acting consistent with the policy. So he thought he could do what he did because he had seen others do it in the past.
That's a weak read, it seems to me. I've seen other people do wrong in the past and get away with it. So it makes it more reasonable for me to do it. It's not quite an appealing.
I think
rationale.
Excuse me. I think I would object to the suggestion that what he was
wrong part. Right?
Exactly. And that's because there are a lot of circumstances where individuals are paid for hours not worked. Again, and that's specific to Fort MYER and also in general. So I can provide citations from other courts if it's helpful for the proposition that paying employees for hours not worked is not invariably
But
theft.
doing so by perpetrating a lie might be different from doing so sort of above board.
Perhaps the form wasn't filled out in the exact right way, but I will say that it's not clear from the record. We do have testimony from a Fort MYER employee that came to the second hearing that signing a timesheet is the appropriate way to effectuate payment for hours not worked. So I don't think it's clear that the paperwork was done in the wrong way. We don't know how the paperwork is done for those other types of examples I listed. For example, the show up time, the hours that are paid in the event that someone shows up and there's bad weather, they still get their ticket, the hours that are paid if someone is improperly removed from the shift, like I read from the paving agreement earlier. It may be that those follow the same procedures. It's not clear from the record, but even if they don't, the matter of the specific paperwork that was used shouldn't be dispositive here. The issue that Fort MYER is saying is that this was theft. And we've given a lot of reasons as to why this is not theft and that it's consistent with the Fort Myers policies. And it's also important to remember that no money actually exchanged hands in this case either. I see I'm at the end of my time, so unless there are any further questions.
Thank you, counsel.
Thank you.
We will give you, Mr. Schuler, 3 minutes in rebuttal.
So start with going to the actual conduct that is known to have taken place, which is that Mr. Spada was directed to sign a timesheet. The record shows he was not authorized to do timesheets, and that he testified credibly that he was compelled to do so by Mr. Briscoe against his wishes. All right. And the record also shows that under the Fort MYER policy, a supervisor is responsible for conduct of a subordinate that the supervisor is aware the subordinate is taking and does not stop. And that was a factor also testified to in the decision to discipline Mr. Briscoe. The statute indicates that conduct simply needs to be knowing, not intentional, for there to be misconduct. And for terms of simple misconduct, the term other than gross misconduct shall mean an act or omission by an employee which constitutes a breach of the employee's duties and obligations to the employer. So there certainly is basis for finding both misconduct here, and in my view, even if it was knowing breach of the rules that was, even though motivated to in some fashion benefit Fort MYER, it can still be gross misconduct because it was knowing and out of the employer's policies. And an important policy here, an important policy that people get paid above board for work that they actually do unless the company makes an exception. And Mr. Briscoe was not the person authorized to make that exception. He never claimed that he was. What he did claim was that he was acting in compliance with prior circumstances, as I argued in my opening statement, where he had witnessed higher level supervisors create a ticket for somebody, signing it themselves, where they thought they had been unfairly taken off of a shift. That's not what he did. He directed a subordinate to make up a ticket that he himself was unwilling to sign. And it had nothing to do with the collective bargaining agreement. He gave express testimony that he didn't take into account the bargaining agreement. And the record also shows that the union steward was there, right? So if there was a bargaining issue here or a labor agreement issue, the union steward presumably would have weighed in and taken that into account. That wasn't part of the equation at all, and it wasn't part of what Mr. Briscoe testified was his reasoning for saying that Ms. Ginyard should be paid more. Nothing to do with
May I ask you a question on another matter that it has occurred to me I haven't checked out, and maybe you can just tell me the answer quickly. From the point of view of the company, does it make a difference whether Mr. Briscoe is found to have had simple misconduct or gross misconduct? It makes a difference to Mr. Briscoe because his benefits, it affects when he'll be eligible again for unemployment compensation. Does this translate into a difference for the company?
I am not an expert in that area, Your Honor, but my general understanding is that the more an employee is paid, the more that affects an employer's rating.
So it does affect the rate.
Yeah.
Okay.
I
sort of guessed that was
whether
true,
any
but I wasn't
individual
sure.
case is large enough to make a difference. I don't know, particularly for an employer the size of Fort MYER with some 700 employees. But in theory, I think that's the way the equation works. again, there was emphasis placed on Mr. Briscoe doing by Ms. Steele that he was doing what he had seen others do. Again, he didn't. By his own acknowledgement, he did not do what he had seen others do. He did not investigate. He did not make a conclusion on his own. He says he instructed Mr. Spada to go contact a higher authority, and that would have triggered what he said he had seen done in the past. And at the bottom line, he said his motivation was to prevent Ms. Ginyard from filing a complaint against the company. The actions he took, he says he took, he acknowledges that were his intention, to go back to that word, weren't guaranteed to see that she didn't, because he didn't follow through to see that somebody addressed her complaint. He didn't follow through to see, he didn't himself personally take her to get her complaint resolved, supposedly. So all of that undercuts the idea that he was acting with the intent to help Fort MYER at the time he took his actions, as opposed to being motivated by something else, or at best reckless in how he effected what he thought was for the interests of the company, at the same time that he was undertaking acts that were clearly against the interests of the company, including directing a subordinate to do something the subordinate was not allowed to do. Thank you.
Thank you, counsel. Thank you both for your arguments today, for your briefs and supplemental briefs, and the case will be submitted.
All right.